Okay, good morning, everyone. Um, Welcome to the virtual training, our very first session out of the four sessions that will come along the way. We apologize for the late start. The reason being that the technical people were and are still um, working with the Portuguese interpreter to ensure that those who would prefer to participate in the proceedings, in these proceedings using Portuguese, are able to do so. Um, However, in the interest of time, we have resolved that we begin as the technical people will continue to work with the Portuguese interpreter to ensure that he is able to join us. But in the event that that is not successful, we still apologize for that. But we will try to share the recording of this session for the benefit of everyone here and those who are unable to be with us, and of course those who are affected by the interpretation issue. Please accept that as teething problems. This is our very first session, and we are hopeful that the next session on the 8th of October should be much better and also start on time and end on time. So my name is Tarisai Mutangi. I am moderating this session. In fact, all of them from Harare, Zimbabwe, and I would at this juncture probably allow the technical people to just give us a few instructions as to how we would be able to access language options for purpose of interpretation. Elma, do you want to come through now to give us those options?
Yes.
Thank you.
Good afternoon, everyone. There are three languages that we'll be using for this session: English, French, and Portuguese. So to listen with French, there is an option at the bottom of your screen for you to be able to select and pick which language that you need. In case you run into any problem, kindly just chat us and we'll be able to assist you. Thank you.
Thank you, Elma, for those instructions. So please contact him via the chat box if you have any problems accessing the preferred language option. So we are all aware that this is an African Court Coalition online training for legal practitioners and CSOs on the engagement with the African Court and the African Commission on Human and People's Rights, which is being offered virtually because of the circumstances we are in as the continent, as the whole world in the pandemic. We definitely would have had this as a face-to-face training, but because of those conditions, those limitations, we are not able to do that. But nevertheless, it was resolved that the training should go ahead. And the training is being offered in partnership with the Rao Olympic Institute on International Human Rights Law and International Humanitarian Law, who are our partners in this process. And we're very grateful for the partnership and facilitating these four sessions that will take place. And from the concept note that was shared before applications were invited, you will realize that the objectives are two. The first one is to build the capacity of legal practitioners to enable them to effectively and strategically engage with these two institutions, the African Commission and the African Court. And secondly, to increase the awareness and understanding on the available implementation mechanisms, effective ways to follow up, and to influence the implementation of decisions that are issued by the African Commission as well as the African Court. At the end of the 4 sessions, or the 4 modules, the first one being the one we are having today, the other one on the 8th, on the 12th, and on the 16th of October. By the end of those 4 modules, the expected outcome of these processes is for us to see enhanced knowledge among legal practitioners. We have their knowledge increased or improved in terms of engagement with the African Court and the African Commission. That way, we are hopeful that it will enhance access to justice in Africa, as well as enhanced knowledge among legal practitioners and those who participate in these processes on the implementation of human rights decisions of the African Court and the African Commission. As you know, legal practitioners and CSOs are key players in terms of engaging these 2 institutions, in terms of ensuring that our people in Africa are able to access justice by engaging these 2 institutions. But not only that, even after the 2 institutions have issued decisions, it is important that we play our roles wherever we are to ensure that the state parties are able to effectively implement those decisions so that they bring about the change, or they redress the violations that would have taken place at the national level. So it is very important that we go through these 4 modules together, and they've been properly designed to ensure that they build upon each other from the time of engagement with the institutions to the time of dealing with implementation of decisions that have been rendered by the 2 institutions. And today, the module today is on the rules of procedure of the African Court and the rules of procedure of the African Commission on Women and People's Rights. Rules are made for the court, rules are made for these 2 institutions, but the bottom line is rules are there to facilitate access to justice. Without knowledge or intimate knowledge of these rules, legal practitioners are not able to effectively engage the 2 institutions, effectively prosecute cases before these 2 institutions. So it was imperative, it was important that we have a discussion on the rules of procedure of the African Commission, rules of procedure of the African Court, to kickstart this 4-legged module that we are going to have throughout this month of October. And to take us through the sessions today, we have 2 presenters. Their CVs are very rich and long. In the interest of time, I will not go through everything in their rich and long CVs, but I think I'll just highlight the essential parts that are relative to what we are discussing today. So Dr. Horace Ajelohun will take us through his presentation on the rules of procedure of the African Court, and later on, Ms. Abiola will also take us through the rules of procedure of the African Court, African Commission on Women and People's Rights. And the method of the presentation is that they'll be allowed to speak for about 30 minutes, definitely highlighting on the key elements that they think we should know as legal practitioners. It is not possible for them to really go through their respective rules of procedure in the allocated time. And once they are done with their presentation, or once Horace is done with his presentation, we will allow some time for questions and comments so that we have a discussion on their presentation, clarifications, and things like that. So we'll rather not interrupt them in their presentation, but what we'll do is please make use of the chat box to put in your questions and your comments. And at the end of the session, we'll read out some of those questions and some of those comments, and also allow you to even participate by giving your verbal comments or your verbal questions and put them to the presenters for them to be able to respond to that. So after we are done with Horace, we then move on to Ms. Abiola after taking a health break, who will present on the rules of procedure of the African Commission. So as many of you may be aware, Horace holds a doctorate in public international law, human rights law in particular, as well as a master's of laws in human rights and democratization from the University of Pretoria in South Africa. But before all that, he had earned for himself a BA degree in public administration and law from the Benin National School of Administration and Judicial Training, and a license in public law from USAM University in Benin as well. He is an extraordinary lecturer at the Center for Human Rights. He is a professor in human rights and comparative law at the University Gaston Berger in Senegal, and also sent by European University in Hungary. He is currently the principal legal officer at the African Court on Human and People's Rights, and has been in that position since 2016. And prior to the court, he used to be the commission as well, as a senior legal expert and a team leader on the project aimed at clearing the backlog of the cases which have been handled by the African Commission. There are so many other things that I can read from his CV, but I'll stop here. If I get some time as we go along, I will finish the rest of the CV. As I said, it's long and rich. But at this juncture, I think I should invite Horace to take us through his presentation on the rules of procedure of the African Court on Human. Horace?
Yes.
Yes.
Well, good afternoon, Tarisai, and thank you. I mean, I thought at some point I couldn't see you on the screen anymore. I think you were off for a few seconds. Yeah, so I was waiting to hear the end of the introduction before I start my presentation. And yeah, good afternoon to you, and good afternoon to everyone. Good afternoon to the participants, and welcome, and thank you to the African Court Coalition for organizing this meeting to share ideas on the recently adopted rules of procedure of the African Court on Human and People's Rights, and also to allow discussion with stakeholders, namely legal practitioners who usually engage with the court, to hear also from them as to what they believe are the changes, the improvement, and so on and so forth. So I'm basically not going to take you through the rules provision by provision. I'm proposing today to introduce you to the rules as follows. First of all, I will make a quick mention of the scope of changes to the rules. That is whether we henceforth be dealing with, so to say, amended rules or new rules. So are these new rules or amended rules? I'm going to share ideas on that. And two, I'm going to introduce you to changes that I believe are pertaining to improve internal operation of the court. Three, I will raise also rules that are introducing, so to say, new provisions, or rather, I would point to what should be seen as novelties, the novelties in these new rules of the court. Four, I will then highlight changes that I believe pertain to the relations with the Commission. Those are changes that seek to implement the complementarity provision in the court protocol. And then lastly, I will insist on changes that are of prime relevance to litigant, and those ones are the bulk of the new rules. Those are the rules that should be considered by litigants, whether individuals or NGOs or respondent state as being the most important rules that would regulate their constant interaction with the court. So to start with the scope of changes, basically here the idea that I want to share with you is that we can consider that the changes to these rules or these new rules have introduced changes that are on the one side qualitative and on the other side quantitative. If you look at the qualitative approach to the changes that have been made to the rules, you can consider that in the previous rules you had 76 rules, and in the new rules you have 93 rules. So you can consider that there were 19 additional rules. However, the inflation is much more significant when you consider the number of new provisions within rules. For instance, if you look at Rule 2 of the new rules on assumption of duties, for instance, in terms of office of judges, you have an increase from 2 provisions within the rule to 4 provisions. And the same applies, for instance, to Rule 31 on representation, which actually also include legal assistance and is also a merger from the previous rule, 28 and 31. So in the old rules, you see that 28 and 31 used to be separate. Now, under the new Rule 31, you have a sort of merger of the provisions that used to feature and the rules 28 and 31 in the old rules. Okay, now also one of the most extensive changes that you can notice in the new rules is new Rule 44 on time to file pleadings. Okay, now here from a single provision. In the previous rules, Rule 37 in the old rules, there's an increase from a single provision to 9 provisions in the new rules. Now, in terms of qualitative or substantive changes, here we can basically refer to rules that are new rules, freshly introduced rules, and that also bring about the major novelties in the new rules. Now, the purpose of these rules is mainly to crystallize practice. You are going to notice that many of the new rules are to the effect of crystallizing what has been under the practice of the court for the past couple of years. Okay, now one category of such rules, the new rules, or the rules that bring about novelties, is the rules that seek to improve or expedite the administration of justice. For instance, if you go to Rule 66, that deals with pile of judgment, the pile of judgment procedure. Here we are talking about cases involving systemic or structural problems in the respondent state, and the procedure that is provided here is for the court to seek consent of the parties, and then the court to proceed to select an application that will follow the expedited procedure, and then in case the court decides to place some applications under a pilot judgment procedure, then those applications are going to be quote unquote frozen. That is, their consideration is going to be adjourned. And then the adjournment may be lifted, of course, in the interest of justice, and processes such as amicable settlement may not necessarily suspend the implementation of a pilot judgment procedure. This is a completely new provision in the rules. This is a completely new practice under the operation of the court, Rule 66, that brings about the possibility or the option of the court dealing with cases under a pilot judgment procedure. And now another such rule is also Rule 89, by which the court has the power to derogate from any rules in the rules of procedure. You remember that in the context of COVID, the court issued a statement on how matters are going to be dealt with. And now we felt like this should also be crystallized in terms of rules. And cases like cases of force majeure, for instance, where there are external or unforeseeable events, such as the COVID pandemic, then in such circumstances, the court should be allowed to derogate from any rules in the rules. So these are basically to allow a more effective administration of justice. The same applies to Rule 90, which deals with inherent powers of the court, okay? And then Rule 93, which is basically a transition from the old to the new rules. Okay, another category of rules involve those that apply to compliance with decisions of the court. If you read Rule 80, the new rules, it is basically a restatement of the provisions of the protocol that decisions of the court are not only binding, but also enforceable. But it goes further. If you read Rule 81, it goes further to also give effect to some practices of the court with respect to compliance, and namely to sort of give flesh to the ongoing procedure of adoption of a framework for compliance monitoring. There is a document before the policy organs of the AU currently seeking to adopt a framework for monitoring compliance with decisions of the court. So this new Rule 81 seeks to sort of give effect to that, to a good part of the proposals that have been made in that framework for compliance, and the effect of the new process that you are going to be seeing in practice in the forthcoming months is: one, that the respondent will submit a compliance report; two, the report will be served on the applicant for observations; three, the court may seek further compliance data from third parties; four, the court may hold compliance hearings and sanctions same with a judicial decision; and five, the court may attach a compliance ruling to its report to the policy organs. So henceforth, there could be a possibility that in cases of non-compliance, a party refers the matter to the court, and the court may decide to hold a hearing on compliance, and that hearing will be sanctions, or the outcome of that hearing is going to be in form of a judicial decision that may be attached to the report that is submitted to the policy organs on compliance with decisions of the court. If you read particularly Rule 81(5) of the new rules, that is mainly the essence of that rule in terms of implementation. Next category of section of rules that also seek to bring about novelties to the practices of the court is the ones that improve access to the court and internal management of cases, and also administration of the court. These include Rule 2, Sub 4 of the new rules that deal, for instance, with the management of elections of the Bureau of the Court, gender representation under the Bureau of the Court. Improve access to the court is under Rule 31(4). And here, there may be need to stress a bit on this rule, because it deals with, I'm going to come back to it when I'm dealing with rules that have a special relevance to litigant. It's Rule 31(4) that deals with the legal aid, establishment of the legal aid fund, and Rule 31(3) that deal with legal aid scheme under the court. So now the next set of rules seek to implement complementarity between the Commission and the court. As you have observed under the previous rules, we used to have a single rule on complementarity between the court and the Commission, or the relationships between the court and the Commission. Now, what you have under the new rules is a sort of upgrading complementarity to a chapter in recognition of the importance of complementarity in the operation of the African human rights system. So you now have a whole chapter 2, rules running from rules 34 to 38. And if you compare with the previous rules where complementarity is under a general chapter, provisions with a single rule, Rule 29 under the old rules, dealing with relationship with the commission, you will notice a significant change. Also, this part of the rules is sort of meant to be a bit more litigant friendly. If you read new rules 38.1, sorry, it expressly provides for the parties to be consulted prior to transferring a case to the commission. Under the previous rules, the court will directly transfer cases to the commission. In these new rules, the court will consult with the parties and seek the opinion of the parties before transferring a case to the commission. A new rule 38.2, in cases of lack of ratification, for instance, or lack of filing of a declaration of recognition of jurisdiction of the court will not transfer, but it will inform the applicant of the option of the commission. So in case the court doesn't have jurisdiction, for instance, it will no longer directly transfer a case to the commission. It will inform the applicant that it doesn't have jurisdiction in this case, but the applicant has the option of filing a communication directly before the commission. Now, the next and last but not least section of the rules, whether these include merely amendment to some of the old rules or introduction of new rules. So the last section is changes that are of prime relevance to counsel and litigant. I've called them so because I believe these rules are fundamental, and they are the basic rules that a counsel and litigant should bear in mind in their daily engagement with the court. And one set of such rules is the ones on commencement of proceedings and supporting document. New rule 40 sub 3 has to do with applications, and here it is stated that applications should be accompanied by copies of supporting document, which may seem obvious, but in particular, decisions relating to the object of application and confirmation of exhaustion of local remedies. In the previous rules, we didn't have any such mention because of course, the rules were not that detailed. Currently, when you are filing an application under the new rules, you will have to make some specific mentions in the application. And this leads me to also say that this rule, particular rule 40 sub 3, crystallizes the court practice of in two respects: in respect of jurisdiction and in respect of admissibility. In respect of jurisdiction, because some of you might have noticed that under the previous rules, this rule was not explicit, but in practice, when you filed a case before the court against a country, they had not filed a declaration and the Article 34.6, then you will be informed by a letter of registry that your application cannot be registered. Now it is mentioned expressly in the new rules in terms of the content of the application and the supporting document that you need to bring together with the application upon filing of the application. So, and then in terms of admissibility, for instance, under the previous practice of the court, but not mentioned expressly in the old rules, you also had to do a prima facie proof of respect of the condition of exhaustion of local remedies. That is that you are asked when you bring a case to furnish information on whether you have exhausted remedies. And such information includes documents. For instance, decisions rendered by domestic court, if you do allege that that you have taken the case to domestic court and that you have exhausted local remedies in that respect. Another novelty or improvement on the rules that are of prime relevance to counsel and litigant is that on format of application. It's still commencement of proceedings, but now here you note specifically in the rule 40 sub 5 that the filing of our application has to follow a certain format. The application itself has to follow a certain format. We used to have already the application form that was sent to the parties upon commencement of proceedings, but now we have more specifications in terms of the application being original or certified, a certified copy, or you being able to file the application in form of a scanned copy or electronic copy and so on. We had situations in the past where an applicant try to seize the court merely by sending a letter. And if you read, I refer you to the case law of the court in terms of format of judgment. The court used quite a liberal approach to the format of application. So these are just being crystallized in the rules in terms of making them express rules. The same applies to content of the application as such. And you have a very extensive new rule 41, which provides for use of application form with some specific directives, such as designation of a single counsel in case of multiple ones, a clear statement of fulfillment of admissibility conditions, particular focus on the exhaustion of local remedies, which is seen to be the most disputed admissibility requirement. And also, very importantly, is that you are required to file now an all-in-one application as opposed to before. Okay, so now you're being told when you are filing an application, you shouldn't file an application in bits and pieces. You are bringing the application, you should come with the full pleadings on jurisdiction, admissibility, and reparations. Well, not necessarily when you are dealing with a preliminary or provisional action, because then you might not necessarily be required when you are filing a request for provisional measures. For instance, you might not be required to bring the entire application, but when you are introducing the main application, it has necessarily to come with full pleadings or submissions on jurisdiction, admissibility, and reparations. And this is because some of you who are used to proceedings before the court may recall that at some point you were communicated to the effect that henceforth, while filing the application, you should supply for both jurisdiction and disability, the merit and reparations, because henceforth the court had decided that it was going to deal with this in total, as in all in one. So other provisions relate also to the issue of standing, and now you are required to bring a power of attorney or to prove standing, and the rule 41(3)(d). Not so much that it is something very new, but now it has been put expressly in the rules, like I've said earlier, in respect of some other rules. Disclosure of identity, rule 41(6). And here there may be a novelty if you read this rule together with the rule on protection of witnesses, whereby now the court is empowered to request from state parties to provide protection to any person who has filed an application before the court as a victim or a witness in a case or proceedings before the court. Sorry. But of course, there's a provision also that the identity cannot be hidden from the respondent, because the respondent is involved in the proceedings. And of course, some of the orders that are going to be the outcome of the proceedings before the court will be addressed to the respondent state. Of course, you may want the respondent state to know who it is dealing with in implementing some of the measures that are ordered by the court. So that is covered in the new rule 41(6). Now, the issue of diligent prosecution, this too is very important. We have seen cases in the past where lack of diligent prosecution led to the sanction of the case being struck off the docket of the court. Now, time for filing pleadings is also a very important one. Again, those who are used to proceedings before the court remember or have had the experience of long or delayed processes on filing of pleadings, where we went up from 60 days, initial days, we went up to months in some of the cases. If you read new rule 44, it seeks to attend to this. And this rule, I would probably say that it is a rule that is trying to stick to reality, because from 60 days, for instance, that is granted to the respondent to respond to the application, we have moved to 90 days. This is in recognition of the challenges that have been faced in the past, some of them due to difficulties faced by respondent, some others due to also challenges faced by the court in processing some of the cases. So now, but one question could be whether equality of arms and equality before the court generally is still respected when we have increased the time for the state. I think this increase of time applies to everyone generally, because if you read rule 40-5, if you read rule 44 generally, and the subsequent rules, they are also to the effect that the applicant is the time granted to allocated to the applicant to file his reply or her reply. That time is also increased accordingly. So basically, there was an attempt in coming about this increase. There was an attempt to find a balance to avoid breaching the central principle of equality of arms and generally equality in proceedings before the court. Another rule that is very relevant to counsel and practitioners before the court is on default. Okay, now in the previous rules, there used to be a bit of uncertainty and lack of clarity as to how the court deals with default procedures. So it used to be only on the request of the parties and not necessarily suo motu by the court. The court moved in terms of practice and used its inherent powers and necessities related to the end of justice to start applying a suo motu power in terms of deciding whether it can give a judgment in default or not, and it has been doing so. So now we have it expressly provided for in new Rule 44.7. Okay, and if a party fails to file pleadings, the registry draws attention to Rule 66, which is old Rule 55, with a final 45 days. So after the initial statutory time that are granted, then the court grants 45 days before it moves on. And now, again, I wish to draw your attention to the fact that these new rules, 44.7 on default procedure, have to be read jointly with the new Rule 63 governing default procedure, so to say, expressly. And this Rule 63 governing default procedure is a novelty. It's a novelty because it now expressly is now stated clearly that the court has power to grant judgment in default suo motu. Now, computation of time. This is another rule that is of relevance or importance to litigants before the court. So what we have to get here is that computation of time is not from the date of notification, but from the date of receipt. Of course, this has been in practice, but it's been stated expressly here. Close of pleadings. Under the previous Rule 55, there was an attempt to cover, yes.
For us, sorry to interrupt. The interpreters are saying you are rather quick in your talking. You slow down a bit so that they.
Okay. Sorry about that. Yeah. So I was dealing with the rules on close of pleadings, and the previous Rule 55 that was an attempt to deal with close of pleadings. Close of pleading wasn't expressly dealt with. Now you do have a new Rule 46.3, which also gives effect to the current practice of the court, and by which now the sequencing is that applicants, except otherwise decided by the court. Now, of course, pleadings can be reopened, but you have to file your pleadings before pleadings are closed. So what you have now in the new rules is that sequencing is of applicant files first, respondent, applicant replies, and that it will stop there. The exchange of pleadings will end there. Yeah, so of course, there may be requests for reopening of pleadings, and then there are certain conditions that are set out very clearly in the new rules. And of course, under Rule 47, new Rule 47, a party may, of course, amend, make a request to amend their pleadings. The next provision, still under the section on rules that are of relevance to counsel or litigant before the court, is Rule 48, which is self-explanatory. I think it still has Rule 48 on the plan of dismissal of application. It still have to be read together with serial rules and the commencement of proceedings and content of applications. Here, again, registry deals administratively with some of the applications. For instance, those that are prima facie or obviously not within the jurisdiction of the court, the registry will not entertain them. The registry will not register those applications to move them to the court for examination because, of course, obviously, in the face of it, these are not applications for which the court has jurisdiction, or in cases where it is very clear that the applicant has not exhausted local remedies, for instance, which is one of the main conditions of admissibility, then under Rule 48, it is made clear that those are going to be dealt with under administrative procedure by registry. Hearing, Rule 52.3, that deals with hearing. A novelty here is that hearing may be in camera for public morality and others, but the novelty here is that the rules tend to be child sensitive by providing that in case the best interest of the child, for instance, is at stake, the court may decide to hold in-camera hearings. The conduct of hearings, you have new Rule 55 that is much more elaborate than the previous Rule 44 dealing with the conduct of hearing. Again, this is reflection of practice. Binding nature of decisions. There is a statement here to the effect that order for provisional measures are binding. If you read the protocol, there's a general provision that decisions made by the court are binding, but I believe the terminology used in the protocol was that of judgment, but was meant to be generally lato sensu. In the large meaning of the word, it used to be decisions made by the court. But I think there was a necessity in the rules to be very specific in terms of order for provisional measures. So new Rule 59.6 seems to attend to that by stating clearly that order for provisional measures are binding on the parties. Next rule is that on intervention, which is under new Rule 61, and it is very sequenced this time around as opposed to the previous Rule 53. One, you request for leave. Two, the request is submitted to the parties for observations. Three, if the leave is granted for intervention, the intervener is then requested to file written observations. Four, these observations are served on the parties. And five, the intervener may be allowed to present their oral submissions. The next rule is amicable settlement, new Rule 64. This rule on amicable settlement seems to do what I would call an economy of procedure, but it also dispels some of the possible confusions in the concomitant implementation of old Rule 56 on out-of-court settlement and old Rule 57 on amicable settlement. So those two rules have been merged today to be a more sequenced, a better sequenced rule, and also to dispel the confusion that I said. The next rule is on strikeout of cases, new Rule 65, that brings about a change in terminology, but also clarity and comprehensiveness in terms of processes outlined under a single provision of old Rule 55. So now one new condition, beside the intention not to proceed, is failure to diligently prosecute cases. If you read new Rule 65 sub 1b, this is to the effect that, there's clarity that is being brought to the strikeout processes before the court. But also any other reason, so it can be, a case can be struck off for lack of diligent prosecution, but also for any other reasons. However, there is flexibility, of course, and a case can be restored under exception of circumstances. Next rule is Rule 77, which I believe should also be brought to the attention of the participant, which regulates interpretation of judgment rendered by the court. New Rule 77 upholds old Rule 66 on interpretation almost pro verbis. However, the change here is that, basically you are having a more detailed provision. Of course, what is notable here is that there is no change in terms of the provision that a request for interpretation does not say stay execution of the judgment whose interpretation is being sought. The same applies to review. And now with review, and this is the last category of provision that I'm going to be dealing with, there seems to be quite some novelties here under the new rules on review. The new rule 78 comes with a slight but very determinate alteration of the old rule 67. One, under rule 77 of the new rules, the terminology is of new fact and evidence as opposed only to new evidence under the old rules. And it might not be very visible at first glance, but a fact could be different from evidence, and evidence might not be fact. So from the old rules that is restricted to only providing about new evidence, new rules 77 and 78 have added fact. Okay. Now, because fact may not necessarily be evidence, as I have said, and vice versa. Two, and the new rule 77 as well, there's an addition of cluster of words. In fact, of evidence. I quote, evidence which by its nature has a decisive influence on the determination of the matter. And, I quote further, could not with due diligence, end of quote, have been known to the concerned party when the judgment was delivered. That cluster of words, which by its nature has a decisive influence, was not in the previous rules. And two, evidence which could not, with due diligence, that cluster of words as well was not in the previous rules. And if you pay attention to this and apply your mind to this, basically, here is that new rule 77 brings about the most liberal approach to review, in my view. And I think being aware of the history of drafting of the new rules, I think some of the discussions that went into adopting these new rules are actually to that effect. That is, that what can have a decisive influence in a case, and the determination of due diligence fall under the interpretative powers of the court, and may largely depend on the circumstances of each case. And therefore, here sits what I just called the liberal approach to these new rules on review. It is going to provide the parties with a larger platform in terms of how they can support and actually be successful in the application for review of judgment rendered by the court. Another key, still on review of judgment of the court, is that a comparative reading with the rules of the commission reveals that there is a significant positive development in the new rules of court. From a very restrictive old rule 67 to a new rule 78, which I've just explained, allows a wider approach to review. If you read the relevant rules in the old rules of the commission, they had already extended evidence to not only evidence stricto sensu, but also merely fact. Now, another provision is the time bar of 5 years, delivery of judgment. Of course, the time bar has been introduced. It wasn't in the old rules. Well, what you can say here is that the very liberal approach to the new rules on review, something had to be a little bit of restriction has to be brought in to limit things a bit. And I think that is the purpose of the time bar, because you can't leave such a very liberal approach to review open-ended in over time. Yeah. Now, of course, at the end of that rule 78, there is no change to the rule that a request for interpretation does not stay execution of the judgment whose review is being sought before the court. So basically, of course, I didn't want to take the risk of taking practitioners and law professionals like yourselves through the rules one after the other. So I thought those were the rules that needed being highlighted and in terms of scope of the changes that were made, in terms of changes pertaining to improvement of internal operation of the court, in terms of rules introducing fresh provisions, and novelties in terms of changes pertaining to relationship with the Commission, in terms of improvement on implementation of decisions of the court and follow-up thereof, and finally, in terms of changes that are of prime relevance to counsel and to litigants. So yes, I will stop here, and probably we have more time to discuss and also to hear your views on the new rules when it is time for questions and further engagement. Thank you very much.
Thank you, Horace. The time for questions and engagement is now. But thank you so much for the presentation, introducing us to new provisions of the rules. Of course, the participants wish if they have copies of those rules of procedures, and I'm sure they're already on the website of the court, new as they are. And of course, for the African Commission as well, I've tried to share some links with the participants so that they're able to download maybe some of for these rules, so they're able to follow the discussion as we go. Yes, so there are a few questions and comments that are in the chat box, but I've also seen a few hands raised, and I'm going to first of all pause my question as I put together the rest of the comments and questions to be put to you for us. And my question is a bit general, but in your answer, please remember to speak as slowly as you can so that the interpreters are able to catch up with the interpretation. To me, it seems as if these changes have been introduced to solve certain problems that the court perhaps or users of the court have encountered previously. Do you have any few examples where you can clearly demonstrate to us to say this new rule on this and that was introduced because the court or the users of the court have been facing these kind of problems, and therefore they're introduced to plug that wall or to open up an avenue so that people are able to access the court and use the court appropriately. So you might want to take that one down, and I'll go to the chat box immediately. I see questions there. The first question that says, does Rule 4, Sub-Rule 5 mean that an applicant has to print and deliver a physical copy to the court? If so, is this not going in the opposite direction as many courts are moving towards accepting electronic filing? So that's Rule 40, Sub-Rule 5. And then Rule 40, Sub-Rule 6 is a question again. Does it mean that the registrar cannot simply serve by way of electronic mail or any other electronic means? And it goes on to say the East African Court of Justice, on the other hand, is at advanced stages of setting up electronic filing portal where all parties must register. It goes further to say, does it seem that the African Court therefore is moving backwards to a brick and mortar court while its sister courts are marching confidently into the electronic age? So I think it's more to do with, with the times we are in. To what extent is the African Court moving towards electronic methods of work as opposed to the brick and mortar, which is the physical way of doing things? I suppose that's that's the meaning of that expression. I have got hands that are up, and I'll allow these hands. I'll allow them to speak. I'll start with Femi. Femi, can you please make a contribution?
Thanks very much. My question really has to do with the status of Nigeria, which has not made a declaration accepting the competence of the court to receive cases from NGOs and individuals. So what optional measures exist that one may explore, and or what measures may be taken to put pressure on the Nigerian state, for example, that has not made the necessary declaration accepting the competence of the court? Because looking at the list of the countries that have made the necessary declaration, there are so few. So what can be done in this regard, particularly for people like us who are in a country that has not made the necessary declaration? Thanks very much for now.
Thank you, Femi. I will move on to Usani. Please make your contribution. Usani.
Can you hear me, please?
Yes, we can hear you. Please go ahead.
Okay. So my question to the presenter is with regard to Rule 45. If I am correct, Rule 40 sub 5 rather, which is commencement of proceedings, which allows the registrar of the court, after an applicant has filed an application, the new rule provision allows the registrar of the court to follow up with the applicant on certain documentations which he may have omitted in the new application. So my question is, would this kind of follow up with an applicant not mean descending into the matter already? And would the respondent still be put on notice? Because such documentation now might include such evidence like exhaustion of local remedies, which applicants are usually very wont to hammer on, but which they usually fail to attach because most often than not, they are in prison and may not know the exigencies of some of this evidence to the application. Would the respondents to be put on notice when the registrar is making this request from the applicant? Thank you.
Thank you, Usani. Caroline, please make a contribution. Caroline.
Are you getting me now?
Yes, we can hear you now.
Yeah, I just wanted to say my question has been taken care of. It was concerning the process of filing originals instead of through electronics. And I was thinking of a developing well where we are fast running. I mean, where the well is fast running with electronics. And I was wondering, just like the other speaker said in the question, whether the African Commission is not moving backwards.
Thank you so much, Caroline. I also had a hand from Barnabas. They have since put their hand down. Do you still want to make a contribution, Barnabas? Barnabas Nyalusi, do you want to make your contribution? Okay, it appears there's no response from Barnabas.
It is covered. Yes, it is covered. My concern is already covered. Thank you.
Oh, thank you, Barnabas. Okay.
Sure.
Horace, do you want to respond to the questions and comments that have been made so far as we wait for another round of questions and comments?
Yes, that is fine. Yeah, thank you, Tarisai, and really thank you to all the participants who have made comment and put question to us. So to start with your own question, yeah, when I was making the presentation, I think I might have been a little bit fast due to time constraints. But let me restate quickly some of the provisions that are, like I said, the initial. In my introduction to this presentation, I said that the main purpose of these new rules were to sort of crystallize practice. And crystallizing practice, of course, you are attending to issues that either the court itself faced or the litigant faced before the court in proceedings that have now been completed. And now, so basically the court is trying to learn lessons from what it has faced in practice in terms of challenges. So let me give you, for instance, a few examples again. On compliance and monitoring, we've received an increased number of requests of compliance, monitoring compliance with judgment of the court in the recent years. So we have more and more applicants writing to us and seeking that the court should intervene and complaining to the court that its judgment have not been implemented. As up to now, we have never had a very clear process on how an applicant can follow up on compliance with their cases before this court. And we have also never had a very detailed process, except for the presentation of report before the policy organs. There have been, for instance, no clear answer to the question, what does an applicant do when time has elapsed and a respondent state has not implemented decisions of the court? If you read Rule 81 of the current rules, they are very clear that these are fresh rules that deal expressly and in details, step by step almost, with processes that have to be undertaken by an applicant if they seek to follow up on implementation of a decision that is being rendered in their favor by this court. Another provision is that on commencement of proceedings, and in particular, filing of applications. So far, there was no provision that you can sit in your office in Nairobi or in Harare, and by pressing send, you would be through a mere email filing a case before this court. Usually, it is been by courier and so on and so forth. But now we've had many circumstances in which applicants were not able to file their applications by courier and others. But by a mere email, we have had cases, for instance, if you read the Penesis matter, a judgment of the court in the matter of Penesis against Tanzania, there was an issue whether the court could accept an application that was filed by a mere letter. So now, if you read the new Rule 44, they deal expressly with this question. If you read also the rules on judgment, the default procedure, they also deal with an issue that used to be recurring before the court. If you read the rules on the review, the last one that I touched on, the new Rule 78 also come as a clear response to a problem that was faced by the court over the past years. So many of the rules, whether amended or freshly introduced rules, have sought to solve problems that were faced by the court in its administration of justice over the past years. Now, does Rule 45 that you have to print and deliver an application? I think probably here, what we may want to do is to have a joint reading of Rule 40 sub 4 with sub 6. Okay. In sub 4, it is very clear that now you can, like I've just said, by a mere email, file an application before this court. So electronic copy of your application attached to an email, you press go or you press enter, and then an application is on before this court. Now, when you read 6, of course, in isolation, it gives you the impression that when you are serving an application on a party, you can't do this electronically. Probably, I would say you have to do a joint reading of 5 with 6. And in any case, as many of those who are participating in this meeting, or those who do not, I inform you that in many instances, the court has used electronic means and digital means as being the first means. For instance, when we are serving an order for provisional measure on our respondent state, for instance, we are no longer using DHL or courier as the first or direct means. We send this by an email as an immediate means of serving the decision on the parties. And thereafter, this is followed or complemented by a transmission by courier. So this is always been part of the processes of the court, and we do this during the closed session of the court, the last session of the court that closed a few days ago. So the court issued order for provisional measures in cases that were very urgent, that involved, for instance, the electoral process in Cote d'Ivoire. And what happened is that the court first served this document on the respondent state by email, and then this was followed by what we used to call the traditional means of serving document on the parties. Now, is the African court going backward in terms of processes? Well, sorry to say this. It's not like I'm trying to defend the court, but yes, I am defending the court because of course I'm part of the court. No, we are not going backward at all. If you are also aware, this court has put in place a number of measures in the recent years, for instance, in terms of rendering a good part of its processes digital. Moving from the old way of doing business to a new ways of doing business. If we had implemented our digitalization processes fully, many of you would have seen by now that, for instance, you can drop some document in a quote unquote drop box or drop place, and the registry will collect from there and also drop there, and so on and so forth. So of course we are almost about to release a sort of quote unquote full digitalization mechanism for dealing with cases before the court. And again, in the few coming weeks, you will also notice a change to the practice directions of the court. Some of the rules that we might have wanted to add to the new rules, the court decided, or is still looking into it, as to whether we should include each and every aspect of the proceedings before the court in the rules, or if we should reserve some of them to be included in the practice direction. And I can tell you that many of the rules that bring about more details to the rules that have currently been released will be included as practice directions in that other document that also serves for providing guidance to litigants in litigating cases before the court. So of course we are electronically how do I put it, cautious, and like I said, rule 40 sub 5 should be read jointly with rule 40 sub 6. Now, the question on declaration to be made by Nigeria on jurisdiction of this court, well, I don't think this falls completely or directly in the current discussion, but well, yeah, I think Nigeria hasn't made the declaration yet, and I guess this is the role of NGOs and civil society to work with Nigeria, for this to happen. We all hope this will happen in the forthcoming weeks or months, or any time that the government of Nigeria may want to decide to do so. I had also a question by Husseini on 40 sub 5 supplementary judicial decision. Yeah. So basically, the question by Husseini was on what we commonly call here in practice request for information. That is when a party has filed an application before this court, and then we receive just a letter stating allegations of violations and recounting facts as they happened in the national sphere or before domestic court, without, for instance, ever either alleging a specific violations, for instance, or providing information to the effect that he has exhausted local remedies, for instance. So the registry will not register the application because, assuming this is very practical, as a matter of fact, assume you receive an application in which the applicant makes no submission on whether they have exhausted local remedies or not. How do you process this application and bring it at the level of the court for the court to do what we did? How does the court make an examination of a matter in which there is lack of information? There's obvious lack of information. So what you do is you do complete investigation, so to say, at the level of the registry to ensure that by the time you register the application and bring it to the examination of the court, you bring about sufficient information for the court to make a proper ruling. Because otherwise, what you'll be doing is you'll be delaying justice, as a matter of fact. You go to the court only to come back, to be instructed by the court to come back to the applicant and gather information. What we do as the registry in terms of being efficient, in terms of managing the time and the life of the application, is you go straight to the applicant and ensure you gather each and every information. Now, it has also been by decision of the court to say, in terms of efficiency, what we want to do is, if, for instance, it is so obvious that an application doesn't fall within the jurisdiction of this court, you need not bring the application to the attention of the court. For instance, if there is no Article 34(6) declaration, which other way are we going to go? Initially, the court used to issue orders only to say that it doesn't have jurisdiction because the state against which the application is being brought has not filed the declaration. Subsequently, the court considered that this could be dealt with by the registry. Now, do we involve the state? Yes, we do involve the state. For each and every processes that is being done in this court, the state is involved. For instance, assuming pleadings have been closed, for instance, and now the applicant files some information, we actually would take the risk of reopening pleadings, seeking that pleadings be reopened so that we can serve that information, even if the information is not that determinate. Even if the applicant has been given enough time to supply information, we still serve this on the other party for information, because we are, of course, aware of the necessity and the imperative, okay, to guarantee and to sustain, to uphold equality of arms and equality between the parties in processes before the court. Yeah, so that is, those are the explanations and the comment that I can make on the questions that were put.
That's okay. Thank you, Russ. I know you're speaking from your heart of these issues. So always remember the pace of talking. The interpreters are following hot on heels in terms of interpretation as you are responding to the questions. There are a couple of questions that are there on the chat box, in the chat box, and one of them is saying, it's asking whether the new rules will improve the effectiveness of the court's decisions. In your view, in what way would the new rules probably bring effectiveness to the court decisions? One is also concerned about, is it Rule 50 sub Rule 6? Let me check again. In terms of the state parties that do not implement decisions of the court, the rules in a way going to address that effectively, or as amended, are they going to bring that, to bring those state parties that are not, implementing court decisions to account, or to do as they are ordered by the court? But I've also a few hands that are raised. I'll just take a few because remember, at the end, towards the end of our session today, the module today, we have a general discussion, a general interactive session where Horace and Abiola will also come back to respond to some comments and questions that we will develop as participants during the entire 2 sessions. So at the end, we'll have another chance to sort of clear all these outstanding comments and questions. But I have Flaviana. As Flaviana is making a contribution, I am looking for Dr. Enos' hand. He has been quite raised for quite some time now. Also to give him a chance to make a contribution. This will be the last round with the Horace, so that we can move on to prepare for the next round. Flaviana. Can you make a contribution, please? Okay, it appears that Flaviana is not responding, and I can't see them on the list anymore for now. Probably it's connection issues. I see Dieudonné Anye. Please make a contribution. Dieudonné.
Hello. Hello.
Yes, please go ahead.
Are you getting me?
Yes, we are.
Okay, I have this worry. How does the court admit that the processes served through electronic means has been received by the parties in a proceedings? Does the party or does party need to reply each order analysis? So I wish to know how the court really needs to confirm this, because it's an electronic means. So I just wish to know.
Thank you. I have Oka Christian. Do you want to make a contribution, please, quickly?
Oui. Oui, j'ai une question. Bon, enfin, je viens de Côte d'Ivoire, comme on peut le voir. Allô? Allô?
Yes, we can. Oui.
OK. L'État de Côte d'Ivoire a renoncé dernièrement à la possibilité qu'a les ONG et les individus à saisir la Cour africaine. Est-ce que les ONG et les individus, maintenant, avec les nouvelles dispositions, ont un moyen alternatif de saisine de la Cour africaine des droits de l'homme? C'est ma question. Je reprends la question ou bien c'est bon? Oui, je disais que l'État de Côte d'Ivoire a renoncé dernièrement à la possibilité qu'a les ONG et les individus à saisir la Cour africaine des droits de l'homme en Côte d'Ivoire. Est-ce que maintenant, avec les nouvelles dispositions, les ONG et les individus peuvent maintenant, de façon alternative, saisir la Cour africaine des droits de l'homme?
Thank you, Oka. I have Kone. Do you want to make a contribution? Isabel, Kone, please make a contribution.
Oui, bon, le son est bon.
Hello.
Please go ahead.
Are you getting me?
Yes, we are.
Yeah, my question was, I will want to know the position of the law concerning decisions that are binding in cases where the state party withdraws before before the decision is executed.
Okay, thank you. And lastly, Ali Hamza, please make your contribution. Hamza, yes. Hamza, are you there? All right, I can't get any feedback from Hamza. I'm looking for Dr. Eno, who has been raising his hand for a while. Dr. Eno, can you hear me?
Yes, Doctor. Good afternoon.
Good afternoon. Please go ahead.
I was beginning to think that you and I have a problem.
Yeah, we do have.
Yeah. Thank you very much, moderator. And permit me to thank my colleague Oras for the very comprehensive presentation that he's made. It's not easy. We adopted these rules just a few weeks ago. And to have gone through with the kind of precision, I think I want to encourage and congratulate him. Just to add also that he and one other colleague, Dr. Zelalem, were the focal points and still the focal persons for the rules of court. And we have worked together on this, but they are the custodians for now when the rules of court are concerned. We're to be joined by two other colleagues, the deputy registrar and the head of legal division, but I think they're occupied with other issues. But I'm glad that I see Dr. Zelalem was on the line, and I'm sure if he wants to speak, he will raise his hand. Having said that, Chair, there was a question you asked as to what has necessitated or what caused the court to review its rules. The revision of the rules, I think, started in 2010, and it has taken 10 years for this exercise to get to where we are. Can you still hear me?
Yes, we can hear you. Please go ahead.
Yes. These rules, the revision have been necessitated because in the course of case management, the court realized that there were so many challenges, and those challenges needed to be addressed to ensure the effectiveness of the court, to ensure easy access to the court, and to also ensure that the persons who come before the court are treated and they get results which they want. So Oras has highlighted some of the issues which the new rules seek to address, but with your permission, let me add a few more. One of which is the question of extension of time. You realize that in the old rules, the parties can request for extension of time indefinitely. And there was no clarity as to what the court could do. I remember there are instances where a party requested for extension of time for 1 year. And there are instances where a party has requested for extension of time severally. So this new rule seek to put some kind of a guideline to manage the issue of extension of time. The second problem we had has to do with intervention. The current rules and even the protocol provides that provides for intervention only with respect to state parties. But we have dealt with cases where the interest of entities other than states have been affected by the decision of the court. So these new rules may seek to make provision for the possibility of other entities whose interest may be affected by the decision of a court to also request to intervene in a particular matter. This could be groups of individuals, indigenous communities, or even individuals themselves. We also have a situation with respect to the security of parties, the security of witnesses, and even the security of experts to appear before the court to give testimony. The current or the old rules do not provide for that. The new rules have made it in a way that states have to guarantee to provide security to parties appearing before the court, to witnesses, to experts. They must make a guarantee to the court that there will be no reprisal against people who appear and testify against states. On the issue of electronic filing, let me just inform your audience that the court has already, as we speak, installed within the registry an electronic case management system. We are working on a system to ensure that the entire courtroom of the court has modern technology, where we'll be able to do live streaming, we'll be able to get testimonies from a party or witnesses who are not able to appear physically before the court. But more importantly, the new system that we are planning to install will ensure for electronic filing and provide parties a possibility using that system to follow developments regarding their cases, to know at which stage their cases are at any given time. Each party will be given a security code that will enable them to access and deal with their cases only to the extent that the court wants them to do. So it ensures transparency. It gives parties the possibility to follow their cases as the case progresses. So we are not going backward, we are going forward. But we could not, in the rules, deal only with electronic filing, because as you know, on our continent, not everybody has access to internet. We also need to provide the possibility for those who do not have access to the internet to be able to access the court as well. So that is why we've provided for all these possibilities to ensure that everybody has a possibility to access the court. There were a number of questions I got through the chat. If you allow me to quickly speak to them. There was one from Michael Nyako as to how will the registry deal with the issue of exhaustion of local remedies. The issue of exhaustion of local remedies, I think, is very contentious. When we receive an application, as I think Oras explained, which is, for lack of a better word, which is naked, we write to the applicant to advise the extent to which they have exhausted local remedies. If they provide information which, as far as the registry is concerned, is not clear, the registry does not make a decision on the issue of exhaustion of local remedies. We submit to the court and the court makes a determination. whether based on the information supplied by the applicant, there has been exhaustion of local remedies. So the registry does not make a decision on that. We simply request for more information and present this to the court. Abdullah asked a question. Avez-vous l'impression que ces nouvelles règles ont apporté de l'effectivité des décisions de la Cour? One of the sections in the new rules is dedicated to enforcement of the decisions of the court. This was a weakness which was not there, which was found in the old rules. And one of the challenges that we've had so far as a court is that the majority of the cases, the judgments of the court have not been complied with. The court cannot sit and fold its arms and litigants come before the court, they get judgments in their favor, but those judgments cannot be implemented. They don't get remedies. So the court has put in place in the new rules a mechanism to ensure that the court itself should be able to follow up on the implementation of its judgments. Chair, you and I, we worked on a framework document together with the Banjul Commission, the Committee on the Rights of the Child, to put in place a structure within the African Union that will enhance the monitoring and compliance with not only the judgments of the court, but the judgments of African human rights treaty bodies. So we think that through the rules and through the framework that we are developing, we'll see an enhancement in the implementation of the decisions of the court. Chair, I know you are out of time, and you said there will be a segment for general discussion. I think I can come back if you give me the opportunity. I thank you, sir.
Yes, thank you, Dr. Ene. Please prepare to come back in the general discussion later in the day. I have lastly, and I have Yare Fall. The hand has been up for as long as Dr. Ene's hand was up as well. Please make your contribution.
Hello?
Yes, go ahead, please.
Hello?
Yes, please go ahead.
Hello? Allô? Allô? Oui, bonjour à tout le monde. J'ai suivi avec beaucoup d'intérêt la présentation qui a été faite, mais je souhaiterais quand même partager une préoccupation. L'objectif majeur qui est recherché à travers cet atelier est de faire connaître la Cour à travers l'Afrique et de s'assurer qu'elle devienne de plus en plus effective, en tout cas sur toutes les parties de notre continent. Mais laissez-moi vous dire que au niveau de la partie ouest de notre continent sur laquelle je vis, la vérité est que cette cour est très, très mal connue. Et elle est très mal connue pour une raison essentielle, c'est que la plupart de mes collègues, parce que je suis avocat de profession, vous disent que cette cour est une cour anglophone. Et même s'ils se trompent, la manière dont les choses se déroulent leur donne un peu raison. Tout se passe comme si les autres langues, qui sont en tout cas au même pied d'égalité que l'anglais, sont plus ou moins exclues. Par exemple, je constate que sur le panel de ce matin, il n'y a pas un seul francophone. Pourquoi ne pas inclure dans ces panels un sachant qui viendrait d'une zone anglophone, arabophone, lusophone? Ça, ce serait une très bonne chose pour l'expansion de la Cour. Je pense que les textes le prévoient. Les textes prévoient une délocalisation non seulement linguistique, mais également physique. Mais si tout se passe à l'est de notre continent, les autres se sentent exclus et ce n'est pas une bonne chose pour l'expansion et l'effectivité de la Cour. Donc, je voudrais attirer l'attention des uns et des autres sur cet aspect pour qu'il soit envisagé une délocalisation non seulement linguistique, mais également physique. Je connais les coûts que ça peut entraîner, mais en tout cas, ça vaut le coup de le faire parce que nous avons une Cour africaine. Voilà, c'est cette contribution-là que je voudrais faire et je pense qu'elle sera entendue. Parce que là, franchement, autour de moi, avec les commentaires que j'entends, les gens ne semblent pas s'intéresser à cette Cour du fait simplement qu'ils se sentent exclus alors que ils font partie intégrante de cette Cour et il faut faire des efforts pour les toucher et pour les intéresser au fonctionnement de cette Cour pour qu'elle soit véritablement une Cour africaine. Merci de votre attention.
Thank you, Mr. Fall. Your point is noted. You would probably be amused to know that Dr. Horace is bilingual. He prefers to speak in English. So I invite him in the afternoon to speak in French so that he can show the diversity and the versatility that he has, and also to show the representation. I'm also hoping that in the next modules, we have more linguistic representation, both on the panel as well as the issues to do with the interpretation. But the point is taken, and we've been incorporated as we go. So at this juncture, I will not allow Horace to respond. You will hold on to your questions and respond, and they have a chance to talk to us again in the general discussion at the end of the program for today. So with the permission of
Chair, with your permission, if you will, if you grant me permission, I think what Mr. Fall has raised, I need to comment on it. If you allow.
Please go ahead. Please do.
Yeah,
please do.
No, I'm very sorry to have requested for the floor, but I thought the comments made by Mr. Fall should be responded to because it is a wrong representation of the court. The impression that the court is dominated or is a court for Anglophones, even though it's a continental court, I think is an impression that is not correct. And if such statements are made, I think should be corrected immediately. I might not be here till the end of the session, so it is important that it is corrected. If you look at the new rules seek in many places to deal with the issue of not only gender, but geographic representation and linguistic representation. The new rules provide that in the recruitment of staff, consideration should be taken of gender, geographic representation, and linguistic representation. In the recruitment of the deputy, of the registrar and deputy registrar as well, the same considerations should be taken into account. So the new rules deal with quite a number of issues to deal with the issue of a language. You've clearly identified the issue that our colleague who presented is a French speaking. He comes from Benin. So he chooses to speak in French. He may want to speak in English if there are questions posed. He may want to speak in French rather if there are questions posed in French. But that is his choice. I'm also bilingual to some extent. I may respond in French if I decide to. Yeah, and as you've indicated, there are many other modules that are coming up where French speakers can come up. And in the composition of staff at the registry, we have a lot of Francophones. I can even say that at the professional level, there are far more Francophones than there are Anglophones. So this impression, I think, is not correct. And I want to invite my colleague, if he shares the speaker, Mr. Fall, if he shares his contact with me, I can engage with him on a personal basis and try to give him more information on this. I thank you, sir.
Thank you, Dr. Eno. I assume you have left the podium for now. Is that correct?
Yes, thank you.
Yes, so as far as my comments are concerned of noting the contribution by Mr. Fall, it has to do with the issue of the program itself. David, I wasn't speaking on behalf or for the court. That is why Dr. Eno had to come in and make that clarification. My reaction was to do with the issue of speakers and as far as the African Court Coalition program is concerned. So I was just about to say, let us take a health break for now. But I see Horace's hand is up. I think Horace would, can you not talk later? Horace, do you really want to talk now or later?
No, Tai. In fact, you had initially said that you were going to take a last batch of questions, and I was taking down. I was taking notes, you know. So I was expecting to actually come back and answer those questions, and they are still here. They're still pending. They have not been covered by the registrar, by the way, because the registrar also dealt with some other issues. So I was hoping to come back and. But if I've heard you say that we are going to deal with this in the afternoon.
Yes.
Yeah.
Yes.
So that is fine. That is fine. We can proceed that way, please. Thank you very much.
Yes. Thank you so much, Horace, for that indulgence. So let us take is it a 15-minute break? 15-minute health break, 10 to 15 minutes, and we reconvene at is it 14:20? Sophia, is that okay? 14:20?
Yes, Tarisai, that's okay.
All right, I'm not yet. That's okay, yeah. So let's take a 15 or so minute break, a health break, and let's reconvene at 14:20. We're moving straight into Abiola's presentation. After that, we have question and answer segment where we have a general discussion on both presentations. So for those who still have got questions for us, please sharpen them, keep them with you. You have a chance to put them to him and for him to respond. Thank you. Let's meet at 14:20. Okay, colleagues, let's resume and move on to our next session. As I already mentioned, the next session we have Madam Abiola Idowu-Ojo to take us through a presentation on the rules of procedure of the African Commission on Human and People's Rights. I have rich CV here of the presenter, who is currently a senior legal officer for protection at the Secretariat of the African Commission on Human and People's Rights, responsible for assisting the working group on extractive industries, human rights, and environment in Africa, and has the communications coordination team and the focal point for the working group on communications and the focal point for the collaboration between the African Commission and the African Court. And I think you recall that this one element that the rules have to address, and our presenters will share some comments and reflections on the interaction of these two institutions, at least at the level of the rules. For instance, in terms of referral of cases and so forth and so on. So it's important that we at least have the focal persons or the focal person responsible for that, talking to us this afternoon. And she also served between 2017 and 2020 as the acting deputy secretary for the commission, and also acted on many occasions as the officer in charge of the Secretariat of the African Commission. She holds an LLB degree from the University of Lagos, Nigeria, awarded in 2002, and a master's degree in human rights and democracy in Africa, awarded by the University of Pretoria in 2003, and a raft of other specialized qualifications. And on that basis, I personally have no doubt that we have among us as a colleague who is familiar in terms of the theory and the practice of these rules of procedure as they've been developed and as they have been implemented by the African Commission and on Human and People's Rights. So at this point, let me allow Madam Abiola to take the floor and take us through her presentation. Then thereafter, we will be able to put questions to her, comments to her, and Horace will join her in that general discussion at the end of the day. Abiola, you can take the floor now. Thank you.
Thank you, Dr. Tarisai. Thank you very much for your kind introduction. And good afternoon to the organizers of this event, as well as all participants. Kindly indulge me. I'm having serious technical challenges, so my laptop is not responding. So I'm working from my phone, and I'm on leave, as you probably can see. So I'm unable to get the kind of technical support that can enable me use my laptop. So I hope participation using my phone would be kindly indulged. Let me say a very big appreciation to the African Court Coalition for this invitation and for the opportunity to engage with stakeholders on this critical issue, which is the rules of procedure of the African Commission, because this is very important for the successful and effective implementation of the rules, which were newly adopted in March 2020. So just like Horace, I would not go rule by rule, especially because the feedback for the pre-training survey has now come in. And the feedback is that a majority of the participants have a good appreciation of both the 2010 as well as the 2020 rules of the Commission. In actually about above 80% are aware at least of the two rules. I'm also mindful of the audience that I'm talking to, who are in the majority litigants, and then we also have a good mix of researchers and academics. So I would, on that basis, try my very best to maximize the 30 minutes, the very tight 30 minutes that we have. I hope I can be heard properly.
Yes, you can it can be heard properly, at least by me. And just to recall to, I know you're under time constraints, but speak as slow as you can so that our interpreters are able to catch up with you. Thank you, Abiola. Please continue.
Thank you very much, Dr. Tarisai, and I'll take it that my 30 minutes are just starting. Okay, on the basis of the feedback that we have from the survey, I think, again, for me also, the focus would be on highlighting some of the key provisions of the work of the rules of procedure of the Commission, flagging along the way the new provisions that are of particular importance to stakeholders who are the target audience of this training, and in the process also we discuss the implications of these rules for engagement by stakeholders with the African Commission. So I had prepared slides, but I would this will be made available by the organizers because we don't have time to actually be going through the slides, and also because I can't use my laptop at the moment. So the outline of this segment would cover a brief background on the working methods of the Commission, and just to present the context within which the rules of procedure of the Commission have been drafted. And then we'll look at the rules of procedure 2020, the background, what are the key provisions, what are some of the novel provisions that we should be mindful of as we engage with the African Commission, And as well, we look at opportunities for further improvement in the new rules of procedure. So going to the context again, because I know that most of the participants are familiar with the old rules of the commission, and these are people who have been engaging with the commission largely. I would just like to highlight some key issues which would help us to appreciate the context or the background to the content of the rules of procedure of the commission. The first that I would like to flag is the scope of the work of the commission, the scope of its mandate, as well as the work that it has done. And because we all know that the commission within the African human rights architecture has a very broad mandate, which is actually open-ended. It just has the mandate to promote and protect human rights in Africa and to interpret the charter. And it has been very creative over the years, starting from nothing actually to getting to this point in adopting various measures to implement this mandate. And over 30 years, it has come up with different mechanisms, soft law instruments, unpacking the charter, and it has developed a very, very wide network of stakeholders over the years. And because of this, its working methods and the rules of procedure are mindful of the scope of its mandate, the reach that it needs to, the need that it needs to reach that it needs to cover, and also, of course, bearing in mind the fact that the mandate covers all of Africa except Morocco, which is yet to ratify the African Charter, having just rejoined the AU in January 2017. So in view of this, over the years, the Commission has adopted, I would just like to highlight like 7 key major areas of its engagement, in implementing the provisions of the African Charter. The first is promotion. We are all mindful or aware of the promotion missions and various symposia and seminars that the Commission organizes. The second is protection, which comprises both the contentious and non-contentious protection mechanisms of the Commission, the contentious being the communications procedure, which the litigants amongst us would be aware of, as well as the non-contentious, which is the constant and ongoing monitoring of human rights on the continent and responses to those emerging situations through various mechanisms, various interventions, including letters of appeal, letters of concern, and various other intervention mechanisms. The third will be state reporting, which I know we are all familiar with. We have the fourth, which is interpretation of the charter, which actually straddles the various aspects of the work of the Commission, but primarily we can locate it within the segment of the work of the Commission that concentrates on unpacking the provisions of the charter, elaborating through various soft law instruments and other tools that help both the rights bearers as well as the state, the rights bearers to understand their rights, as well as the states to understand their obligations, and of course the various other stakeholders to be able to hold states to account using these various soft law instruments. And then we have capacity building, both within the Commission and of course capacity building for stakeholders. We have the special mechanisms of the Commission, which is a thematic approach to key human rights issues on the continent deserving of particular attention. And lastly, collaborations, primarily, and most closely with the African Court on Human and People's Rights, based on its the legal and complementary relationship that they have with each other. So on the basis of that, I would then go into the content of the 2020 rules of procedure of the Commission, just to, this is just to provide the background to understanding what are the improvements and what are the key provisions that we need to draw our minds to. I think maybe another thing that I also need to note, which also informs the working methods of the Commission and the content of the rules of procedure, is also the resources of the Commission. This is a Commission that is part-time. It's serviced by a secretariat based in Banjul, where the commissioners don't have the opportunity of day-to-day direct supervision of the secretariat. And the secretariat currently has 9 lawyers covering the whole of Africa, serving 11 commissioners, 17 special mechanisms, and 54 member states. So these are all of the things that we need to bear in mind. So I would skip the background, because initially I had wanted to present the detailed background, but perhaps just to say that the rules of procedure of the Commission is authorized by Article 2 of its charter. Yes.
Madam, sorry to interrupt. The interpreters are now on my neck again to say,
okay,
can the presenter speak you know, like reading a speech.
Okay.
So to speak.
All right.
Yeah, that's so that they can catch up with. You know, with internet connection is a bit, you know, difficult than when you are face to face. Thank you, madam. Please proceed.
Thank you. Yeah. Kindly excuse me. It's because I'm trying to see what to do with the time. Okay.
No,
so
don't worry. You have a bit of time to really wrap up at the end. So yeah. So don't worry so much about the time. We'll try to give you a little bit more or what you need to really tie up your presentation.
Okay.
Thank you.
So, you know, the basis of the rules of procedure, as we all know, is Article 42 that allows the Commission to define its own working methods. And this particular rules of procedure will be the fourth set since the inception of the Commission. We engaged stakeholders through consultations pre and at the very early stage and just before the adoption of the rules of procedure. And the rules came into force on the 4th of June, 90 days after the adoption. In terms of the application of the rules of procedure, rules 141, 142, and 145 speak to the application of the entry into force and the application and the issue of non-retroactivity, which I will go into later as I go into the final provisions of the rules of procedure. But just to highlight at the beginning that the intention, if you look at the rules 141, 142, and 145, particularly 141.2, is that there is a transitional phase for the application of the 2010 rules of procedure. So the Commission did not adopt a blanket approach to applying 2020 rules in that they are not, it will not be applicable across the board to all pending cases. And at the same time, it moved away from the it has moved away from the application of the continuous application of 2010 rules to all pending cases up until their completion. But what it has provided for is that any phase of the communications procedure which has been completed or is it has actions that have been taken, for instance, submissions that have been made by parties under the 2010 rules would be considered based on the 2010 rules. So the non-retroactivity actually is in respect of past actions or measures taken in relation to stages of the communications procedure that have been completed. As we all know that the communications procedure of the Commission is in phases. We have the seizure, the admissibility, and the merit stages of the communications procedure of the Commission. And of course, this will be, I'm explaining the non-retroactivity in the context of communications, but in general, the rules are non-retroactive. Past actions that the Commission needs to make a determination on, in respect of which they are already submitted.
Abiola, madam, can you hear me? It seems we have lost you now.
Il doit avoir un problème d'Internet. Non, il n'y a pas de souci.
Abiola. Okay, it seems to have we have lost the presenter for now. Horace, are you there?
Yes, hello? yes, I'm here.
Okay, am I back? Yes, okay.
Oh, yes, you are back, madam. Please proceed.
Okay.
Sorry.
Thank you very much. Okay.
That's okay.
So,
that's okay, Horace. Thanks.
Thank you very much. So it's also, it was born out of such observations, and then over time as well, with challenges being observed in the course of using the rules of procedure of the Commission, policy directives also emerged from the Commission to the Secretariat. So the current rules of procedure are actually also sometimes affirmations and documentation of existing policy directives of the Secretariat, of the Commission rather, that have been applied over time. Some are also based on observations received from stakeholders based on the challenges that they've had in using the rules of procedure of the Commission. including state parties and the diverse set of stakeholders that we engage with, and also best practices, borrowed from other systems, amongst others. So it's a combination of so many reasons and so many sources, if I can put it that way. Now, going to the rules of procedure, there are 7 major parts. The first part is the general provisions, which basically talks about the status, the composition, the internal governance, and membership, and all of those things. And this will cover rules 3 to 19 of the rules of procedure of the Commission. And I would like to flag a couple of, new rules for the attention of the participants in this regard. I think the first in that regard is Rule 3. Which affirms the organ status of the Commission, which for the first time is being included in the rules of procedure of the Commission. As we all know, there's been a lot of debate about the organ status of the Commission, especially because it's not explicitly listed as an organ in the Constitutive Act of the AU. And of course, these have implications for administrative and budgetary issues, amongst other things, and even decision making. So the affirmation of the autonomous and organ status of the Commission is stated in Rule 3. Under Rule 8, we have a further, a more detailed clarification on the issue of incompatibility when it comes to the activities of commissioners vis-a-vis their positions as commissioners and independence expected of them. It further clarifies how the Commission would engage, and it makes room for such commissioners to be allowed to make submissions before determinations are made regarding the incompatibility of the activities with their positions. And this, of course, was also born out of certain practical experiences that the Commission had. Codes of conduct have been introduced in Rule 11, as Rule 11 binds members of the Commission to observe the principles and codes of conduct stipulated in the rules, including as it relates to recusal and confidentiality. Again, this was born out of practical experiences, including the engagement of the Commission with the PRC in 2018. And then Rules 22 and 23 speak about financial responsibility. They've been there, they are not new rules, but I just wanted to highlight this because these are also issues to note in engaging with the Commission. And so they speak to funding, the fact that the Commission is essentially funded by the AU. And if there are financial, technical, and other forms of partnerships, there are requirements of disclosure, actually pre-financing, there should be disclosure. There's need for documentation in form of MOUs signed with the Commission, inclusion in the budgets of the Commission for the year in respect of which the support is being provided. So if support is going to be provided for 2022, it has to be factored into the budget of the Commission from next year. And of course, the need for the Office of Legal Counsel to clear those kinds of agreements. And then, of course, another issue to note under this part is the issue of confidentiality, which again is not a new issue, but is something that is important for stakeholders, because sometimes there are the perceptions that the work of the Commission is shrouded in secrecy, but there are confidentiality requirements, especially as it relates to its communications procedure. And this is replicated again in Rule 24 of the new rules of procedure of the Commission. Rules 25 and 26 address special mechanisms, which again are not new provisions, but a point to be highlighted also for engagement, because there is a possibility of stakeholders engaging the Commission through these thematic mandates, and also the possibility of expert membership in some of these thematic mechanisms. There are 17 of them, 13 thematic and 4 administrative. And recently the Commission adopted standard operating procedures regulating membership as well as the governance of these special mechanisms, and they're on the website of the Commission. These SOPs were adopted in March 2020 as well. Of importance are provisions relating to the sessions of the Commission, rules 27 to 37. Again, not new, but they are important also for engagement, since we're also talking about engagement of stakeholders with the Commission. As we know, the sessions of the Commission are the largest human rights gatherings on the continent, and we've had 66 of such ordinary sessions and 28 extraordinary sessions. Now, the rules of procedure of the Commission provide that In the past, we had at least 2 ordinary sessions, but now the rules of procedure of the commission provide for 4 ordinary sessions and the possibility of extraordinary sessions where the need arises. And the reason again why this has been done is a concretization of existing practice, because in actual fact, the 4 sessions of the commission, the 4 quarterly sessions of the commission had become institutionalized, and even the so-called extraordinary sessions had actually become institutionalized, so they were no longer extraordinary. And so, and also because the commission realized the need actually to keep having these sessions based on the backlog of cases and the number of other things that it needs to deal with, the commission has also realized the necessity of having at least 4, meeting at least 4 times in a year as a matter of standard practice. And this is why this has been standardized and incorporated into the rules of procedure 2020. Of course, around the sessions of the commission, there are a series of engagements, including with the NGO Forum, and the commission has engaged with the NGO Forum more than 37 of such meetings over. Notable also is the inclusion of the possibility of transmitting the live transmission of the sessions of the commission, given the developments in technology as provided for under Rule 27 of the new rules of procedure of the commission. And then Rule 30. Guarantee unfettered access by all participants, to public sessions of the commission that are hosted outside of the host country of the African Commission. So this is a documentation of a challenge which the commission has sought to address on a couple of occasions, and just to put it in writing, these are reflected in the hosting agreements that are signed with individual states, but it is now incorporated directly into the rules of procedure of the commission. Rules 39 to 40 and 63 to 66 address the records and the various reports of the commission and their publication, which are key provisions for engagement and accessing information for stakeholders. These include our institutional reports,
I think the presenter is having connection issues again. I had given a few seconds, hoping she would reconnect in the process, but it appears this time is taking longer to do so, at which point I could possibly call upon Horace, who is always on standby, to fill in the gap as we see whether we're able to reconnect with the presenter. Horace, maybe as we try to reconnect with the presenter, do you have any reflections on the interaction of these rules of the court and the rules of the commission? How do they come together? In what form and under what circumstances? Do they speak to each other, and for what reason, for what purpose? Probably you can appraise us on that as we were to record with Abiola, please.
Thank you, Tarisai. Can you hear me?
Yes, I can, please.
It's really unfortunate that our colleague has been facing technical issues because I think our presentation is very important. This is our system as a whole, as you are aware. And these two organs, particularly, at least by statute, by treaty, they do speak to each other through the complementarity principle brought by the protocol to the protocol on the establishment of the court. So I really hope she's going to be able to come back and complete her presentation, because otherwise we are going to be missing a good part of the conversation. Anyways, as you have requested, let me say very quickly, hoping that she's going to join to come back. A few words about where the two rules meet. Of course, where the two rules meet would have the foundation, would find a foundation in the provisions of Article 2 of the protocol establishing the court. This is the so-called provision on complementarity between the Commission and the court. That is that the court has been established with the main purpose of complementing the protective mandate of the African Commission. And as such, one notable point that needs to be made at this junction is that if you compare the old rules of the Commission on the one side and that of the court, of course, they were harmonized in 2010 before entering into force. And I think during our meeting in Dakar, the two bodies came together and spoke to each other and had a reading of the rules together and came up with harmonized rules. And that is why you had Rule 118 in the rules of the Commission that were quite extensive in terms of how cases should be brought by the Commission before the court. And on the other hand, also there was a rule in the provision, in the rules of court as to instances in which our relationship between the Commission and the court. Now, what has emerged from this new rules dispensation, if you allow me to use that terminology, is that both sections on complementarity in the two rules have experience of have met quite extensive amendment. Now, one issue, for instance, is how processes are going to unfold before the court when the Commission is taking cases here, and how the court is going to send cases to the Commission. One notable difference, for instance, from the court to the Commission is that while under the previous rules and in practice, the court would transfer cases to the Commission by means of decisions. Now, this is no longer going to happen that way. It is going to happen by means of through administrative channels. That is basically that the court, if for instance, it finds that it doesn't have jurisdiction in a matter, mainly because, mainly for lack of deposit of the declaration under Article 34.6 of the protocol, then the registry of the court or the court will address a correspondence to the parties to the effect that the application, the court doesn't have jurisdiction to hear this application, but with a specific mention that because the concerned state would have probably ratified the protocol, ratified the African Charter, the Banjul Commission still has a competence to hear the said matter. Now, conversely, when you read the new provisions in the rules of the Commission on cooperation with the court, and particularly on the issue of transfer of cases, I think some of those issues have also been covered in terms of trying to address the challenges that were faced in trying to implement Article 2 of the Protocol on Complementarity during the dispensation of the old rules. I think I've seen Abiola quickly. Yeah, I thought she's back. So Tharisa, I think I will just hand over, because she needs to complete her presentation. And we also, I can come back later.
She does, yes. So definitely be ready to come back later on the issue of complementarity, and I'm sure she's going to make some remarks as well on that issue. Viola, are you back with us?
I am, yes, and apologies again.
Yes,
Technology is failing me.
That's okay. Please take it up from where you have left. Let's continue. Thank you.
Thank you very much, Dr. Tarisai. I think I was speaking to the issue of the reports of the Commission, and particularly the new provision on relating to the activity reports of the Commission that are submitted to the AU policy organs. And I had pointed out to the participants that the new Rule 63 of the Rules of Procedure of the Commission provide for the annexation of comments or observations of state parties to the activity reports of the Commission before they are published. This is a new provision, and it's a compromise position that was born out of the practical experiences of the Commission in seeking to protect the integrity of its reports, while at the same time addressing the concerns and observations of state parties. So I'll quickly move to the next section, rules 67 to 74, which cover relationships between the Commission and stakeholders. This is not a new provision, these are not new provisions, but I just wanted to flag this also for the attention of participants on the basis of the implications for engagement with the African Commission. So as we know, within the framework of these rules, the Commission not only engages with states, it grants observer status to CSOs based on Resolution 361. It grants special affiliate status to national human rights institutions and specialized human rights institutions, which is also a new element, in its relationship with national human rights institutions based on Resolution 370. And this grants certain rights and privileges to those organizations that have these affiliations with the Commission. And this is important for stakeholders to note. Again, another important provision is the introduction of focal points of state parties under Rule 69. When it comes to, I think this was also born out of practical the realities of the Commission, the fact that there are always changes in focal points. Sometimes you send a document to the Ministry of Foreign Affairs, which are aligned ministries, and then you copy them to Justice Ministry, and you don't know who exactly is supposed to follow up on what. And on the basis of that, given various engagements with stakeholders, these are recommendations that came from, for instance, the regional seminars that the Commission conducted recently, as well as some of the past practices of the Commission. So it's been concretized in these new provisions. Next, I will go, since I'm trying to use the working method of the Commission for the clusters, I'll go to promotion activities. So we have this primarily entail promotion missions, as I mentioned earlier, and other promotional activities and state reporting, with which the majority of the participants are familiar. Notable new provisions would include Rule 79, which speaks to a new timeline for shadow reporting under the recommendation to state reports of the Commission. Initially, the timeline was 60 days, and now shadow reports may be submitted by the Secretariat at least 30 days before the examination of the relevant state report, affording more time to NGOs to submit shadow reports and national human rights institutions to submit alternate reports. Rule 80, sub-rule 4, also provides for a role for national human rights institutions in following up on recommendations in concluding observations of the Commission. And this is also it is very instructive for purposes of promoting or ensuring compliance with recommendations of the Commission. And so this is a novel and notable progressive provision. I'll quickly move on to protection activities of the Commission, which are under Part C, having just discussed Part B of the new rules. Under Part 3, we have the protection activities. And again, as I said, we have the contentious and the non-contentious mechanisms of the Commission, which I mentioned earlier. Under the non-contentious, or should I say straddling the contentious and non-contentious, will be matters of emergency that are provided for in the rules. They are not new. but maybe perhaps to highlight a few new inclusions under the rules. First, to note that Article 58 of the Charter provides generally for the Commission's reaction to matters of emergency, and it gives the Commission it mandates the Commission to bring these matters to the attention of the AU policy organs, and as well under its rules of procedure to the attention of the Peace and Security Council of the Commission. And so over time, the Commission has engaged with these matters using different kinds of intervention tools, because the Commission has come up with a series of intervention tools, using resolutions, using missions, as we had in the case of Somalia and a couple of other conflict and crisis contexts. The Commission uses resolutions, and then it also uses its communications procedure, but it has sparsely, barely, it has not really used this procedure in relation to its communications procedure in the context of communications. So therefore, it is very, nice to note that we have a new rule under Rule 101 of the new rules of procedure that provide for just to be taken by the Commission in the context of communications. Of particular note is that while Article 46 of the Charter, has this open-ended provision that says that the Commission can resort to any appropriate method of investigation, which can apply to any context in addition to any aspect of its work. There's now this specific provision in the context of communications. And another positive note is that the Commission can actually delegate this investigation, the investigative powers, to other persons or bodies, which allows the possibility of participation by CSOs and other stakeholders. So 101 provides for investigating measures that can be adopted in the context of consideration of communications in order to clarify the facts. And this is very important for noting for purposes of engaging with the Commission. Still speaking to the issue of matters of emergency, we have the provision in relation to protection missions, which have been, in existence. The Commission has been engaged in a couple of protection missions, both SWOMO2 or at the request of the AU policy organs or the PSC, including the missions to South Sudan, to Burundi, the mission to the Sahrawi, which could not be properly concluded. And I just wanted to flag this. And the communications procedure is also another framework that is used in relation to Article 58. Speaking to the communications procedure, maybe perhaps just to bring it to your attention that over the years, the Commission has entertained, I think as at the last 66 ordinary session, 745 communications have been filed with the Commission. We have 206 pending, and the Commission then has dispensed with 539, including 147 on the merits. And again, I'm sure this will be a point on which participants would want to engage. So I would rather wait for the questions than delve into this very long topic because there's a lot to say around this. But just to also flag a new provision in relation to the communications procedure, rules 104 to 106 provide for the participation of third parties in communications. And it explicitly provides for an amicus curiae regulatory framework, as well as intervention by third parties that have direct and substantive interest in communications before the Commission. These are progressive provisions, as we might all be aware, that previously amicus curiae was barely a sentence in one of the old rules, in the old rule of procedure of the Commission under the 2010 rules, and the framework for using that tool of engagement was not clarified. As a result of that, the Commission was unable to make the most of it, as well as stakeholders were not also able to make the most of it. And one of the key issues that I would like to highlight is that the new rules now provide, first and foremost, it clarifies the concept of amicus, because one of the things that the Commission has had to deal with in practice is the issue of interest. And now it provides explicitly that an amicus is someone who doesn't have a direct interest, who is not a party. Although, of course, such an organization or person, which is open-ended, it could be a natural or a legal person. would have interest in the legal and policy implications of the matter that is being dealt with in that communication, because that is what would naturally stir the interest, of such a body in engaging. But a direct and substantive interest is then limited to the possibility of third-party intervention, which is a different procedure. Another useful point to note is that it now explicitly clarifies when an amicus intervention can be made. It says at any time after the state party, the respondent state has been requested to submit on admissibility. And the reason why this is important is because for many years, the Commission received a lot of premature amicus interventions, which were filed sometimes simultaneously with the complaints. And of course, there was no communication, properly speaking, before the commissioners at the time of the filing of such amicus briefs. And there were also issues of interest, disclosure, sources of information, and all of those things, which have now been addressed by the new rules. Another issue is the issue of access to information by potential amici. Where do they get the information from? And while there's still ongoing discussion around the fact that this problem has not been definitively laid to rest, because it's a challenge that stems from Article 59 of the African Charter on the confidentiality requirement in relation to communications entertained by the Commission. The new rules of procedure now provide for possibility of access to information in at least two ways. Number one, once an amicus has been admitted, it says that the amicus would be given access to the files subject to confidentiality requirements, which is a great thing. And then another thing is the possibility of the Commission itself soliciting amicus intervention, such that even if information is not out there for potential amici to use, the Commission in itself can solicit interventions. And in doing so, it will definitely make information available. But of course, even the procedures around how the Commission would implement, the solicitation of amicus interventions and all that are yet to be fleshed out. And these are some of the things that I would mention when we're talking about opportunities for further development in view of the new rules of procedure of the Commission. I think I'll quickly, leave this because it's a very important point. I wanted to elaborate on it because it's something I'm very passionate about. But I just wanted to highlight that, it's very crucial to the jurisprudence of the Commission. It's crucial to the Commission, given its limited capacity. As I mentioned, the part-timers, commissioners are part-timers, legal officers are very few. The ratio of legal officers, I did mention there are 9 to 206 cases, is definitely very low. And then, of course, it's very important in the context of Africa, where we have a lot of indigent complainants before the Commission. So there are so many reasons why this provision is progressive. Again, in relation to communications, is another important point to note on new provision is Rule 115 on seizure by the Commission. So in the past, the Commission had 3 clear stages: seizure, admissibility, and the merits. And of course, now, in order to save time and to help the Commission to narrow down to focusing on analyzing substantive arguments that are put before it, seizure is now administrative. It is dealt now by the Secretariat through the Executive Secretary. And just at the just concluded 66th ordinary session, we put together an internal framework for operationalizing the new rules, or the new rule on seizure, which was adopted by the Commission. So the details have been fleshed out by the Commission. So the requirement now is that seizure is dealt administratively. The initial overlapping provisions of under Article 56 that actually relate to admissibility, for instance, exhaustion of domestic remedies, a timeline within which cases were filed, have now been taken out, and it's just preliminary information relating to the facts are now under the Rule 115. And again, there's a timeline within which the Secretary is supposed to finalize seizure decisions. So this also helps to save time. The Secretary can therefore communicate seizure decisions intersession, subject, of course, to the internal procedures that have been put together for the Commission to take ownership of such decisions. And it's only seizures, or should I say communications, that are not seized, or where there's any confusion or any question as to whether they should be seized or not, that are then referred to the Commission. Again, there's a provision also under Rule 115 that talks about where complainants are distinct from the victims. It requires sufficient proof that the victims have consented to being represented, or why such proof of consent cannot be provided. And again, whilst the Commission has over the years adopted a very broad approach to locus standi, which is the ability, access to the Commission by litigants, there have been practical challenges in that, we've had situations where litigants have complainants who are not the victims have dropped cases, and the Commission is unable to continue because it cannot have access to the victims, or even situations where the victims are not, there's no sufficient clarity around the identity of the victims, such that maybe even the remedies that are issued at the end of the day can be effectively followed up on and actualized. So as a result of a number, I cannot go into the details because there are so many, like I said, this is a product of so many years of debate and analysis. And as a result of this, it was, and most importantly, I think there was at least one case where a communication was filed on behalf of the president of a country against the country. So there have been some contexts where the Commission, as a result of which the Commission then decided that, yes, the approach, the locus standi approach remains broad and open-ended, but such proof of consent should be provided, and at least the reasons why they cannot be provided should be articulated when cases are being submitted. And I think this is also to sort of like promote diligence on the part of litigants. Again, on communications procedure, Rule 1161 also has a novel and progressive inclusion in that now submissions on admissibility and demerit. So after the communications have been seized administratively by the Secretariat, they are now, with the first point of communication with the complainant would then be for the complainant to submit both on admissibility and demerits, and therefore, so there are no two different stages for submitting on admissibility and then on merit. So this saves time, number one, and then secondly, it also enables the Commission, because the Commission is also aligning this with its wider working methods. It also helps the Commission to be able to have a good appreciation of the facts, the substantive, the contentious issues, as at the time that the first set of substantive submissions are made before it, and for purposes of determining what kind of cases should go to the court, because this was also a practical challenge that the Commission did experience in litigating before the court, in that the court doesn't phase out submissions as have been clearly presented by my colleague, while the communications procedure of the Commission was in 3 clear distinct stages, and submissions were being made at these 3 clear distinct stages. So this is also progressive in terms of time, and also in terms of facilitating submission of cases to the court. Rule 1192 provides for review of admissibility decisions. So this one lays to rest some debate and a little bit of inconsistency around the jurisprudence of the Commission on this. And based on equity of arms, the Commission provides for review of admissibility decision. Rule 1194 speaks to default decisions, that the fact that the Commission would take a decision based on facts before it where the respondent state fails to respond, provided that the facts before it are reviewed by the Commission, and they are found to be sufficient proof of the matters before the Commission. So this again is an affirmation and documentation of jurisprudence, because this has been the practice of the Commission based on its jurisprudence in the case of Communication 29204, Institute for Human Rights and Development versus Angola. So this has been the practice, and it's a documentation of existing practice. Rule 121 also on communication speaks to decisions on reparation and cost. And so now the rule provides for the possibility of the Commission deferring consideration on reparation and cost for a separate review following adoption of decisions on the merits. Again, this allows for the complainants, especially now that they have to front load admissibility and merits submissions, sufficient time after they've received a decision on the merits to put together arguments in support of the measures for reparations that they seek under the communication that has been submitted before the Commission. And it also allows the Commission to be able to give sufficient attention to such matters. And lastly, on the issue of communications, I would like to highlight Rule 124, which talks about withdrawal, strikeout, and listing. Again, this rule provides that the Commission can withdraw, strike out, and then release cases in the event that cases that are that have been struck out are brought back and sufficient argument is adduced for their releasing, and the commission finds it really necessary in the interest of justice and for other reasons to release such communications. Again, this is bringing the rules of procedure of the commission in line with existing practice, because since 2012, the commission has actually been striking out communications for want of diligent prosecution, largely because, in order to clear its database and to ensure that cases are not just pending before it and they are not being attended to by the litigants. And also withdrawals have over time been the practice of the commission, where the litigant actually voluntarily decides to withdraw from the matter. Quickly, I would speak to the issue of implementation. On implementation of the decisions of the commission, which is a major challenge with not just the commission, the entire African human rights system and the entire international law system, if I can say. The commission has added some provisions to the new rules of procedure, for improving the chances of compliance. Hello. Hello?
Yes, sir.
Am I being heard?
You can proceed.
Okay.
Yes.
Okay.
We
All right. I'll wrap up shortly.
That's okay. Oh, there you are. Yeah. Okay. Yeah, I can wrap up now. Thanks.
Okay. Okay. I'll be wrapping up shortly. Thank you for your patience. The new rules of procedure of the commission in Rule 125.2 now allows the commission to task national or specialized human rights institutions with affiliate status to monitor the implementation of its merit decisions. So this is a new provision for purpose of trying to improve the compliance framework within the work of the commission. Another point that is important for implementation is the reference that I had made earlier to the introduction of focal points in member states under Rule 69.3, which is also allows for the commission to be able to identify who to speak to in order to know what is going on with respect to decisions that have been taken. And as was mentioned by the registrar of the court, when he was speaking to earlier on, he did mention that the commission, the court, and the Committee on the Rights and Welfare of the Child are putting together a study around the tripartite framework, tripartite study rather, around the framework for improving compliance with the decisions of the various African human rights bodies, so this is also something that is being finalized, but in the meantime, the provisions of the commission, the provisions of the rules of the commission broadly provide for implementation framework, and it provides for the commission to adopt any mechanism that is deemed necessary for purposes of ensuring implementation, and the rapporteur for cases are tasked with that responsibility of making recommendations to the commission. And as we might all be aware, that in the past, the commission has adopted different mechanisms. There's been a hearing, at least in one case, in the Endorois matter, there have been other forms of. We've had a hearing, and I think recently we also had a hearing regarding implementation of provisional measures. And there have been some other measures that have been taken by the commission. They are open-ended, so it is expected that this framework would feed further into it will both be a combination of what is already obtained or what already obtained and best practices that have been gathered. It will feed further into the working methods of the commission, and as well help to develop a framework that the AU policy organs can use in helping to ensure implementation of decisions of these various bodies. Quickly, I'll move to part 4. That speaks to the relationship between the African Court and the African Commission. Sorry, just a moment. Before that, I also want to just mention Rule 126. Initially, the Commission's rules of procedure provided for legal aid, but in practice, there were no funds for this. And so with the adoption of a legal aid fund of the human rights organs of the AU in January 2016, the Commission has included this in its rules of procedure, and what we're waiting for is the operationalization of this fund with the appointment of the board and the relevant structure being put together by the African Union Commission. Then again, the Commission in rules 130 to 134 makes provision for its relationship with the African Court and the African Committee of Experts, which is again in relation to there's already an should I say established collaboration between the two bodies, and again between the amongst the three. Amongst the court, the committee, and the commission, on a number of occasions, they've had joint initiatives, including the tripartite study compliance that I mentioned. Now, Rule 130 sets out a simpler approach. So it documents that. Then on the relationship, between the commission and the courts, Rule 130 of the new rules of procedure sets out a simpler approach on seizure by the commission. As we all know, the commission and the court have the closest relationship based on the complementarity rule, and the relationship has been they've had harmonized rules of procedure since 2010, and they've been engaging. And now the new rules of procedure of the commission now provide for a simpler approach to seizing the commission seizing the court, in that it now provides that the commission will seize the court before taking any substantive decision on communications that are before it. Again, this was born out of a series of debates or engagements between the commission and the court, as well as practical experiences of the commission in litigating before the court. And it is expected that this would simplify submission of cases to the court, and as well preserve the jurisprudence of the African human rights system. Then the rules 130, just a second. Yes. So again, the new rules of procedure of the commission, in talking about how the commission would seize the court, it provides for the consent it provides now that the commission would seek the consent of the original complainant before referring cases. Again, this was born out of practical experiences of the commission, given its limitations as a part-time body, and the need for it to be able to continuously have access to information that it will use to prosecute cases before the court. And also because it was noted that in some cases, actually some litigants might not want their cases referred to the court, but primarily in order to ensure that the victims and the original complainants before the commission continue to engage with the process, in order that the commission can have access to relevant information for diligently prosecuting these cases before the court. Rule 137, as I mentioned, documents the relationship between the commission and the Committee on the Rights and Welfare of the Child, basically reaffirming the importance of this ongoing relationship with the body. And lastly, I would like to speak to further opportunities for improvement. And at the heart of this element of my presentation is Rule 140 of the new rules of procedure of the Commission, which again is new. Rule 140 allows the Commission to be appropriately flexible and reactive in filling in the gaps in its procedures through the issuance of practice directions on specific matters. So it provides that the Commission can issue practice directions. And this is a very progressive provision. It's very crucial for continuous improvement of the working methods of the Commission and its efficiency. And it's also an opportunity for stakeholders to continue to engage with the Commission as they use the new rules of procedure and they identify areas for further improvement. Recommendations can be made to the Commission, for purposes of identifying areas where there might be a need to adopt practice directives for further clarification, for elaborations, and as may be necessary. And then lastly, on this point, is that within the framework of the rules of procedure, which allows the Commission to engage with AU policy organs, especially with respect to the implementation of its decisions. Notable is a new decision, not so new, decision by the Executive Council, which was adopted in June 2018, relating to the operationalization of the PRC subcommittee on democracy, governance, and human rights to follow up on the implementation of decisions. And this is also one area where the Commission could further look at its rules of procedure, of course, bearing in mind the ongoing study on the compliance framework. But the Commission could also look at this for purposes of seeing how to improve its implementation mechanism under its rules of procedure, especially in light of Rule 140 that allows for practice directions. I think I would stop here and then I would provide further clarifications when questions are put to me. Thank you very much, Dr. Tharisa, and thank you all.
Thank you, Abiola, for the presentation, and sorry for the interruption with your connection there. We have now exceeded our promised time for ending this module. So what we're going to do now is to combine the feedback that is meant for you, Abiola, and to combine it with the final discussion where also questions could come in for or us. You already has a couple of them that are pending he needs to respond to. So at this point in time, I don't know that there's anything in the chat box. As far as questions are concerned, I'll have a look at that while some participants are making their verbal contributions. I've got Flaviana. You've been waiting for quite some time now. Do you want to take the floor and make a contribution, please, Flaviana?
All right, thank you so much, our facilitator, and thank you to the presenter, both Dr. Harris and the last presenter. As I've listened from the first to the second presentation, and I have one question. The other one were addressed by Dr. Harris before. So I have just one. Is the new rules, I'm sorry if I haven't heard it clearly, but I would just want to know if the new rules have just came with the recommendation or some provisions which is going to cure the issue or the permanent issue which has been cracking in our heads on the non-compliance of the state actors on the recommendations or decision of the Commission and the court. And this question goes to both presenters because I know they got some answers. I just want to know if we got the panacea for this kind of problems, because it's really actually been striking our heads, especially for us who are litigants on this matter. When you have recommendations and then the states don't comply, it just gives us a hard time. Thank you so much. I really appreciate it.
Thank you, Flaviana. I have a hand from Gab. Gab, why? Can you make a contribution, please? I'm not getting any feedback from there. I'll move on to William. Would you like to make a contribution? William Maitri, William Wenger, can you make a contribution, please? Your hand is up. Maitri, are you there? There is no response again, and here is a participant. I can see the name Dale. It looks like a computer name. Maybe move on to Isa Salim Ahmed. would like to make a contribution, please? Isa? Isa, are you there?
Yeah, I'm here.
Yes, please go ahead with the contribution, please, very quickly.
Thank you very much. My question goes to the second presenter on Rule 140 on the practice direction. The rules says the Commission may issue practice direction on specific matters. I would like to get more clarification on the said rules on how does the Commission will issue the practice direction on the specific matters. If that direction are there, or it depends on the matter that are put to them before them. How does that practice are? Thank you very much.
Thank you, Isa. Adbayo, would you like to make a contribution? Adbayo? Adbayo, are you there? There's no response as well. Let me check if there's still another hand up. I don't see any further hand up, but I think I saw something in the chat box as far as questions are concerned. Attila says, with regard to the new Rule 3 and the new rules of procedure in general, what does this mean for the enforceability of a decision in states which are a party to a case or other third state parties? This definitely is a comment that, or a question that came during Abiola's presentation. I assume it's directed to Abiola to respond. Is there in the chat box, so you're able to look at it? It's from Attila Kisler to look at it and be able to respond to it. Robinson Makundi says, why Rule 5 sub Rule 3 provide for the extension of time to be total discretion of the court and not being upon parties assign good reasons for their delay? I hope you get an idea of what is being asked there. Rule 45 sub Rule 3, the provision of extension of time seems to be the discretion of the court and not being upon the parties to assign good reasons for their delay. But there's a question mark there. So I think, Horace, you are getting a drift of this particular question. If you do, or if Robinson can clarify it to make it more easily readable and understandable, we really appreciate. So far, the question that I'm seeing, and as I said, we've already entered into our general discussion at the end. We need to wrap up as quickly as possible. But if there are questions and further comments out there, let us have them in the chat box. But for now, I'll give an opportunity to Horace and Abiola to respond to the comments and questions that pertain to them. And of course, I'm aware of Dr. Eno, who promised to speak further on some issues, provided he's still available to do so. Who wants to go first? Horace, you want to go first? I think let Abiola catch your breath as you take up some of the questions and comments, and she will come after you. Horace.
Okay. Thank you very much. Let me do this very quickly. I promised, and also upon the intervention of the registrar, now I wish to proceed in French. Rather, our colleague from Senegal is made his remark about us conducting this meeting fully in English from the beginning. So from here, I think I would rather shift to French. Donc, j'ai pris quelques questions auxquelles je vais essayer de répondre et j'espère que les collègues interprètes me reçoivent et que les participants aussi me reçoivent. Donc, je vais intervenir en français, du moins jusqu'à la fin, du reste jusqu'à la fin du séminaire et pour répondre à la demande du collègue du Sénégal qui a soulevé cette question-là. Et pour compléter l'intervention du greffier de la Cour à cet égard, il faut noter que effectivement la Cour a quand même fait de très gros efforts pour ne pas donner l'impression qu'elle est penchée, qu'elle est plutôt inclinée d'un côté du point de vue linguistique. Et je crois que c'est plutôt seulement une impression, mais pas là du tout la réalité. Bon, en soutien de ce que le greffier a dit, par exemple, on peut noter que la majorité des juges de la Cour, en tout cas l'actuelle composition, en tout cas plus de la moitié sont des francophones. Et donc, on ne peut pas dire nécessairement que la Cour a une inclinaison linguistique anglophone. Bon, maintenant, pour aller aux substances des questions qui sont pendantes et que j'ai pu relever, il y a d'abord la question de la mise en œuvre des décisions de la Cour. Non, désolé. Il y a cette question qui était pendante au sujet de la transmission électronique. Et il y a Dieudonné, je crois, qui a demandé si on peut, en pratique, s'assurer que une partie a reçu une notification qui a été faite par voie électronique. Je voudrais commencer par dire que de plus en plus, les parties, au moment où elles nous saisissent, au moment où elles nous transmettent leurs conclusions, le font de plus en plus par voie électronique. Et donc, si une partie saisit la Cour par voie électronique ou transmet des documents par voie électronique, il est donc évident que la Cour pourra également, par ce truchement-là, répondre à cette partie-là. Et nous avons de plus en plus développé ce mode d'interaction, comme, dans tous les cas, comme le mode premier ou le plus rapide ou le plus efficient lorsque nous sommes en contact avec les parties par voie électronique. Mais sinon, dans tous les cas, une fois la communication électronique effectuée, la Cour s'attelle toujours à transmettre quand même les mêmes écritures par les autres voies initiales traditionnelles ordinaires, donc par voie de courrier, soit pour confirmer ou tout simplement pour s'assurer que le document original est parvenu à la partie concernée. Il y a Oka qui a demandé s'il y a des moyens alternatifs de saisine suite, je crois, au retrait des États ou par rapport aux États qui n'ont pas fait de déclaration de reconnaissance de juridiction de la Cour au terme de l'article 36.4 portant création du protocole portant création de la Cour. Je crois que sur cette question-là, il n'y a pas de voies alternatives. Il faut souligner simplement que lorsque un État n'a pas fait la déclaration de reconnaissance de juridiction de la Cour, le moyen alternatif que nous appelons par ailleurs la saisine indirecte de la Cour, dans le langage ordinaire, c'est la voie de la commission à Banjul. Puisque, quand vous lisez les dispositions de l'article 5 du protocole portant création de la Cour, il y est prévu que la commission peut saisir la Cour par accès direct sans besoin du dépôt de la déclaration de l'article 34.6. Et dès lors donc qu'un État a ratifié la Charte africaine et a ratifié le protocole portant création de la Cour, la Commission africaine peut saisir directement la Cour après que le requérant, lui, ait saisi la Commission d'une communication. Donc, voilà le seul moyen alternatif qui a été prévu par le protocole dans les situations où l'État concerné n'a pas fait la déclaration de reconnaissance de juridiction de la Cour. J'ai une question de Caroline qui demande quel est l'état d'exécution d'une décision après que l'État ait retiré sa déclaration. Donc, est-ce que lorsqu'un État a retiré sa déclaration de reconnaissance de juridiction de la Cour, l'État est toujours tenu ou obligé d'exécuter la décision et quel est le sort de cette décision? Bon, je voudrais vous inviter, et je crois qu'elle a soulevé spécifiquement le cas de la Côte d'Ivoire, si je ne m'abuse, je voudrais vous indiquer que je voudrais vous renvoyer à l'arrêt rendu par la Cour dans l'affaire Sibi Gooré contre Côte d'Ivoire. Dans cette affaire-là, si vous allez à la section sur la compétence de la Cour a tranché clairement sur cette question. D'ailleurs, la jurisprudence de fondation, la jurisprudence mère en la matière, c'est dans l'affaire Victoire Ingabire Humboza contre Rwanda. Cet arrêt rendu par la Cour en 2016, dans lequel, lorsque la Cour se prononçait sur le retrait du Rwanda, la Cour a indiqué clairement que le retrait par un État de la déclaration de reconnaissance de juridiction n'a pas d'effet sur les affaires pendantes. Et donc, il est clair que lorsque la Cour a rendu un arrêt contre un État qui reconnaissait sa juridiction à l'époque où l'arrêt a été rendu, le retrait ultérieur de la déclaration de reconnaissance de juridiction ne peut, a fortiori, pas avoir d'impact sur l'obligation de l'État d'exécuter la décision. Yare, qui a soulevé le problème de la délocalisation linguistique, je crois que nous avons largement répondu à ça. Flaviana, sur le défaut d'exécution, est-ce qu'il y a des dispositions dans le nouveau règlement intérieur qui gouvernent la question du défaut d'exécution? Bon, on ne peut pas dire que le règlement intérieur, le nouveau règlement intérieur de la Cour règle la question de la solution au défaut d'exécution des arrêts de la Cour. C'est-à-dire, qu'est-ce qui peut arriver dans les situations où un État n'exécute pas les décisions de la Cour? En revanche, I think someone is having their micro open and this is disturbing. Hello, can you hear me? Hello.
Yes, Horace, please go ahead. We can hear you.
OK, merci. Donc, sur la question de l'exécution des décisions de la Cour, je crois que, comme je l'ai indiqué dans ma présentation, il y a bien une toute nouvelle disposition qui a été introduite au règlement intérieur et qui gouverne plutôt la question du suivi de l'exécution des décisions. D'accord? Et qui indique presque étape par étape quel est le mécanisme de suivi d'exécution des décisions de la Cour. Et donc, ce mécanisme-là, on l'espère, va aider la Cour à renforcer le dispositif de suivi d'exécution des arrêts. Par exemple, une nouveauté qui a été introduite par ce règlement intérieur, c'est le mécanisme des audiences de suivi d'exécution. C'est-à-dire que désormais, la Cour peut, au cas où un État n'a pas exécuté l'un de ces arrêts, convoquer une audience de suivi d'exécution où les parties se présentent et présentent leurs arguments et leurs conclusions, l'État notamment, quant à savoir les raisons pour lesquelles l'État n'aurait pas exécuté cet arrêt de la Cour. Et comme le greffier l'a rappelé également, je l'avais également mentionné, en fait, cette disposition qui a été introduite au règlement intérieur n'est que la matérialisation dans les statuts, donc dans les textes fondamentaux de la Cour, et d'un autre processus qui est en cours devant les organes politiques de l'Union africaine en ce moment, c'est-à-dire le processus d'adoption par le Conseil exécutif de l'Union africaine d'un cadre de suivi d'exécution des arrêts de la Cour et sans doute en général des décisions rendues par les autres organes des droits de l'homme. De tout, est-ce qu'on ne peut pas condamner les États en défaut à des astreintes, comme le fait la Cour européenne des droits de l'homme, etc. Je crois qu'on peut retenir deux choses en la matière. D'abord, il faut dire que, oui, la Cour, en ce moment, le fait déjà. Si vous lisez certains arrêts rendus par la Cour au cours de l'année 2018 et de l'année 2019, et même au cours de l'année 2020, vous noterez que désormais, la Cour applique la méthodologie ou la méthode des astreintes directement. Si vous lisez les chapitres conclusifs, c'est-à-dire les dispositifs des arrêts rendus par la Cour, il y est mentionné presque systématiquement maintenant qu'en cas de défaut de paiement d'un montant alloué en réparation à un requérant, en cas de défaut de paiement dans un délai indiqué, l'État défendeur sera assujetti à des astreintes sous forme de renchérissement du montant initial au taux de la Banque centrale de l'État concerné. Dans la plupart des arrêts rendus contre la Tanzanie, vous avez ça, mais également des arrêts rendus contre les autres États. Donc, c'est une forme d'astreinte. Et deuxièmement, comme je viens de l'indiquer, il est désormais prévu que la Cour peut organiser, tenir des audiences en suivi d'exécution et rendre des décisions à l'issue de ce processus. Donc, si par exemple, l'État établit que la Cour établit, désolé, que l'État est en défaut d'exécution, la Cour peut le constater par un arrêt. Cette constatation peut bien entendu donner suite à des astreintes, à une condamnation à des astreintes pour défaut d'exécution. Enfin, on peut présumer ainsi. J'ai une dernière question par Makondi et qui demande s'il est prudent de laisser à l'entière discrétion de la Cour à la règle 45.3 du règlement, s'il est prudent de laisser à l'entière discrétion de la Cour la prorogation des délais. Bon, je crois que ce qu'il faut faire, c'est de lire l'entière règle 45 et non la sous-règle 3 à elle seule. Parce que les deux premières sous-règles de l'article 45 sont bien claires pour dire que, bien entendu, comme vous-même vous l'avez mentionné dans votre question, il y a des conditions d'examen d'une demande de prorogation de délai. Et ces conditions-là, bien entendu, l'examen par la Cour et la décision de la Cour concernant la demande de prorogation de délai est assujetti à ces conditions-là. Et donc, par exemple, c'est le respect du délai imparti, la preuve que le requérant n'a pas fait exprès de déposer ses conclusions hors délai, les raisons pour lesquelles le requérant aurait besoin davantage de temps pour déposer ses conclusions. Donc, voilà à peu près ce qui peut se dire sur ces questions qui sont pendantes. En ce qui concerne les relations entre la Cour et la Commission, pour finir, juste quelques secondes pour finir, sur les grandes réformes qu'on pourrait estimer que les deux nouveaux règlements intérieurs ont introduits en matière de complémentarité entre la Cour et la Commission. Un élément très notable, c'est, par exemple, la question de la saisine de la Cour par la Commission. Sous le régime des anciens règlements intérieurs, et il y avait le problème de savoir, il se posait la question de savoir qu'est-ce qui adviendrait des cas dans lesquels la Commission saisit la Cour après qu'elle se soit déjà prononcée de manière substantielle sur l'affaire qui est pendante devant elle. Supposons que la Commission ait déjà rendu une décision sur le fond avant de saisir la Cour d'une requête. À partir de ce moment-là, les difficultés qui ont été rencontrées en pratique dans la coopération entre la Cour et la Commission, la saisine de la Cour par la Commission, ont amené les deux institutions à réfléchir. Et je crois que ceci a été reflété dans les deux règlements intérieurs. Désormais, le problème est réglé puisque, par exemple, au niveau de la Commission, elle ne saisira la Cour qu'avant toute décision de substance, c'est-à-dire dès la saisine. Et donc, si la Commission saisit la Cour dès la saisine, il n'y aura plus de défi quant à savoir ce qu'il adviendrait à des décisions rendues au fond par la Commission avant la saisine de la Cour. Donc, il y a pas mal d'améliorations. Je tenais simplement à souligner particulièrement cette amélioration-là. Merci pour le moment. S'il y a d'autres questions, bien entendu, je suis disposé à y répondre.
Thank you, Horace. Abiola? Abiola, do you want to come in now? And in your remarks, please, may you kindly respond to a query or a question raised by a participant who would love to know if there's a way lawyers can help with the workload of the commission, considering the limited hands presently at the commission. So these are more hands being offered the commission. What can lawyers do to assist with the workload of the commission? So please take that into account as you make your probably final remarks and respond to the issues, to the questions and comments directed to you. You have the floor, Abiola. Please go ahead.
Okay, thank you very much. Let me start in the order in which I have identified both the questions that you summarized for me, as well as the ones that I saw in the chat box. Starting with Flaviana, who had wanted to know, sorry, the line was breaking when she was speaking, but what I picked from what she inquiry was whether the new rules make any provisions in relation to improving compliance with decisions of the Commission, bearing in mind that it's frustrating when you have decisions and you don't have any means of implementing them, sort of. And to that, I would say that there are a few new provisions. The first is that the 2010 rules already provided a framework for the first time on follow-up on implementation. That was the rule 112, and it's been replicated under the new rule 125. And one of the key points to note in that framework that was provided, apart from the fact that, yes, the Commission set out the procedure for writing the states, asking them to submit information within 180 days, getting information from the complainant and all of those things, and reporting to the AU policy organs. One of the key elements of that framework was that the Commission could, on the advice of the rapporteur, that's the commissioner responsible for that communication, resort to any appropriate means of trying to ensure implementation. So it's, again, a very open-ended provision that allows for the Commission to be as innovative as possible. And as I mentioned, there have been different approaches in the past. We've had a hearing, we've had a resolution, and then the new rules also provide now that the Commission should include such in each of its activity reports that are submitted to the Assembly, to the AU policy organs. And then it's also provided that national human rights institutions can be mandated, since they're on ground, to help to track, because that's one of the challenges of the Commission. It doesn't have on-ground presence to help to track. In the past as well, the Commission has, every promotion mission of the Commission also entails following up on decisions in relation to that particular country. So the Commission mainstreams or has mainstreamed over time follow-up on implementation into different aspects of its work. State reporting, questions are asked, every mechanism that it uses in doing its work. And so one of the things that is being done right now, as was mentioned by the registrar, is that all of these existing mechanisms, as well as best practices from other bodies, are being put together for purposes of trying to see come up with a compliance framework that would help to move both the commission as well as the other EU human rights bodies from this point to a better framework where compliance can be better ensured. Again, in terms of the new rules of procedure, I think the fact that national human rights institutions can be mandated to provide information to the Commission, I think is a very key provision. And then this was born out of series of engagements that the Commission has had, because one other thing that has been discovered is that non-implementation is not necessarily as a result of lack of political will. Sometimes it's because of the fact that the framework for hello.
Proceed.
Yeah, it's also because sometimes.
Please proceed.
Yes. So sometimes it's also because the respondent states need to have clarity, on what needs to be done, and there needs to be, engagement between the Commission. And I think this might be the same even for the other human rights bodies when it comes to implementing. So the Commission has recently held series of regional consultations on how to improve compliance with its decisions. And these are some of the feedbacks from this engagement, and some also have gone into this wider compliance framework that is being put together, and which, as I mentioned, elements of this can be fed into the working methods of the respective bodies as we, once this is concluded, because there's already that broad framework that allows the Commission, amongst other bodies, to adopt all relevant or all necessary measures, towards ensuring compliance. So it's an ongoing process. And then there's also a question regarding Rule 140. there's a question. The question is that, what does this mean? Does it? Hello?
Yes, please proceed. We can hear you.
Okay.
As you wrap up, please.
Okay. Yes. So the question, the participant wanted to know whether this means that the commission would be issuing practice directions in relation to matters before it, or it to be doing this suo motu. And as I mentioned earlier, the practice directions, the provisions of Rule 140 actually is just an express statement of inherent powers that the commission already has, because the commission has inherent powers to make further clarify and elaborate on its rules of procedure and its working methods. And so this is an explicit provision that can now actually be taken advantage of by stakeholders in drawing the attention of the commission to certain areas of its work that probably need further clarification. I gave an example, for instance, of the amicus curiae process, because it now provides, we have a provision now that says that the commission can solicit amicus curiae interventions. The stakeholders may want to know how, and what are the frameworks for this. So there are areas where attention could be drawn, and of course the commission itself can suo motu, given its practical experiences as it continues to use these rules, decide that there are certain areas where it wants to issue directions to elaborate on some of its working methods, and also to guide the stakeholders in the engagements. And just to say that it's not as if the commission has not been issuing tools before. They are not called practice directions explicitly. For instance, we have guidelines on submission of cases and communications before the commission. We've had those for more than 2 decades. And so the commission has been issuing those kind of tools, but now there's an explicit provision that says that it can actually adopt, should I say, sub rules, or should I say, further clarification of its rules, for optimal performance in the implementation of its mandate. There's also a question from Robinson on Rule 45.3. I don't think that's for me, because the question is about timelines, and 45.3 of the rules of procedure of the commission speaks to the conduct of its business, so it's not for me. Adaku wanted to know whether with the new rules of procedure, the vulnerable groups such as women would have better access to the to the commission and the court. And in response to this, I would say that one of the key areas of the work of the commission actually is to set up thematic mandates that focus specifically on the rights of vulnerable groups. As I mentioned, we have special mechanisms that focus on the rights of women, on the rights of indigenous persons, and the rights of the elderly. So already these frameworks are in place. And so these special mechanisms are an entry point for specific attention to be given, or to be drawn to issues relating to vulnerable groups. Information relating to the human rights situations can be brought to the attention of the commission. And if necessary, the commission could, through these special mechanisms, decide that some of these matters that are brought to its attention, they would decide the appropriate, intervention mechanism. It could be that maybe the commission decides that, given the information reaching it, it should issue press releases, or it should issue a resolution, or the commission wants to bring the attention to the matter to the attention of the AU policy organs under Article 58. So there are already frameworks for such the issues relating to such vulnerable groups to be brought to the attention of the commission, and for the commission to use its various intervention tools. And when it comes to communications, of course, the mandate of the commission covers all of the provisions of the charter, including the rights of vulnerable groups. And as such, one of the areas where the commission has also been, one of the things that the special mechanisms focusing on the rights of vulnerable groups have been trying to do also, especially on the rights of women, also is to encourage, litigation around issues relating to the rights of women. But of course, litigations have to be initiated by, by the users of the system, and they cannot be, initiated so much by the commission. Of course, Oluwafemi wanted to know how to help the commission in light of its limited capacity. I would say there are many ways. I think one of the first ways that I've mentioned, and we appreciate the concern and the interest, is the possibility of intervening as an amicus curiae, as it's now been clarified in new rules of procedure, because that's one way that latest arguments, comparative human rights law, and and various other tools that can help to enrich the jurisprudence of a commission, and speed up the processing of communications, improve the quality of communications, can be contributed to by lawyers and other third parties. So I think that's one entry point. Another entry point would be legal assistance to indigent complainants before the commission. The rules of procedure of the commission provide for legal aid, we've had situations where victims have been left in the cold when the complainants who filed the cases on their behalf say that they are no longer willing to proceed, or where they don't have the relevant they don't have the requisite tools to make their arguments. So one of the things that the commission is trying to do is to put together a database of lawyers who are working, and in the past the commission has referred litigants to CSOs that have observer status with the commission, just to refer them to the pool and to ask them to contact them. But of course, there's also the possibility of individual lawyers or CSOs writing and saying we are offered these services, and when such cases arise, the commission could know exactly where to direct the indigents to. The commission also welcomes fellows and interns at its secretariat. That's another way to contribute to the work of the commission, and as well take the opportunity to learn more. We could have fellows come in dedicated to working on certain aspects of the work of the commission that can be contributed at the end of the day. If it's a lawyer that has an established been seconded to the commission, of course, subject to all those other provisions under the rules of procedure in relation to technical and financial support that have to align with the wider AU rules on, on financial matters. And just to say that recently the commission adopted a policy on fellows and interns. Technical support to the commission. It's yet to be publicized. It's been cleaned up, but this is something that would also be made available to the public, and it will help to understand better how stakeholders can engage in this manner. And of course, the NGO forum that convenes around the sessions of the commission is another place for getting information on how lawyers can assist the work of the commission. We've had a lot of academic think tanks that have partnered with the commission in elaborating certain aspects of the provisions of the charter, in developing soft law instruments. We've had people provide the expertise during panels that are organized during the sessions of the commission, and usually such engagements are born out of the exchanges during the NGO forum. You get to know more about the work of the commission. Sometimes interest groups congregate around certain issues of interest, and then they bring this to the attention of the commission and they partner. So these are some of the ways that you can, engage with, contribute to, and help to add value to the work of the commission, given its limited internal capacity. Lastly, I'll address the question, a question that I saw in French. I tried to make to understand it. It's from Gentil, and what I understand is that Gentil was asking why the African human rights system and the Commission and the Court are not inspired by comparative bodies such as European Commission and European Court, and especially in dealing with the issue of implementation. And I just wanted to say in this regard that in fact, this is one of the key provisions of the African Charter. Articles 60 and 61 enjoin the Commission to be inspired by comparative international.
Mommy, the driver is around. No, you can wind up. You can wind up, Vienna. Okay. The beauty of working from home, I can see. There's so much demand on Abiola.
The driver is around.
Yes. Are you back now? Or...
I'm so sorry.
No, please don't apologize.
And I'm on leave as well.
Please wind up. Please wrap up now. If you can wrap up now, please.
Apologies. Okay, thank you so much for your understanding. I just wanted to bring the attention of Gentil to these provisions of the African Charter and to say that there are many aspects of the work of the committee, including the implementation framework has been inspired by the practices that we have observed of similar bodies. And lastly, Dr. Tharisa, you had drawn my attention to a question by Attila. I could not find it in the chat box. I think it came through while I was disconnected. So I'll be grateful if you could just let me have the question again so I can address it. I think that'll be all for now. Thank you very much.
That's all right. That's all right, Apila. I definitely wish to wrap up these proceedings, and I would like to call upon Dr. Eno to probably be the last speaker, and of course acknowledging Michael Nyako, whose hand was raised for quite a long time, and my intention was to call upon him to make his contribution just before Dr. Eno comes in to wrap up. But I'm glad that he has managed to do so on the in the chat box. Thank you so much, Michael. Dr. Eno, do you want to wrap up for us, responding, or either just finalizing your final comments on the issues that we are addressing before we went for the break? Thank you, sir.
Yeah, thank you, Tharisa. I think my two colleagues have some sort of responded to some of those issues. As you indicated at the beginning, this is like work in progress, and we did not expect that we're going to exhaustively cover everything about the rules of the two organs. Even between the commission and the court, there's still a lot of work that we are doing to actually benefit from the complementarity. So our rules are trying to bring us together. We are putting in place mechanisms to see the extent to which we can better serve the African people and the continent in terms of promoting and protecting human rights on the continent. So from the court, I want to take this opportunity to, first of all, thank Horace and my other colleagues who contributed to this, but also to thank Abiola. As you understand, she's from leave, but she decided to find time to come and join this meeting. But more importantly, to thank the coalition for the initiative to organize this. As you all know, this was to have taken place, I think, last month. But since our rules were to come into force only last week, the coalition was kind enough to take that into account to shift the meeting to accommodate us as well. So we're very grateful for that. And we continue to look forward to working with not only the coalition, but other stakeholders, because the promotion and protection of human rights is I think it's a slogan of the African Commission that it is our collective responsibility, and the court is always ready to work with stakeholders towards this aim. So I thank you very much, Tharisa. Thank you, colleagues, and we look forward to participating in similar initiatives in the future. Thank you, sir.
Thank you, Dr. Eno. The program says I was supposed to give vote of thanks and final remarks, and I think Dr. Eno is just, has basically done that. To thank the coalition, to thank RWI for, supporting this module and 3 more modules to come, and to apologize for overshooting the time with 1 hour. Probably it's also an eye opener in terms of the time time needed for us to be able to ventilate these issues. We will look at this with a view to ensuring that there's no wastage of time next time we convene the second module, but also being realistic about the timelines that are required for presenters to present, and for us to be able to, the participants to be able to engage the presenters meaningfully. So we will look at the time spent today, under those 2 optics. And of course, the patience of the participants. We thank you for your continuous engagement. Looking at the participation rate, it never really changed significantly. Of course, it changed a bit after the 3-hour mark, but we managed to remain engaged and remain participating in the proceedings, and that is a very good sign of approval of the proceedings to us, and we thank you for that. Like I said, really, if you look at the sequencing of the modules, they really build upon each other. So I have no doubt that those who have participated today, they can't wait for module 2, which is coming on the 8th of October, focusing on strategic engagement with the African Court and the African Commission and lessons from other regional human rights systems. So that question that is to do with drawing inspiration from other regional systems, definitely we will have a rich conversation, pitching our own system with others. How are others doing it? How better are they doing it? In the one area mentioned, in the area of implementation, what can we learn from our colleagues, even as we're in the process of putting together a framework that will enable our human rights bodies to effectively discharge their obligations, and also to ensure that their decisions and recommendations are implemented effectively and in good faith by state parties concerned. So I'm personally looking forward already to the next module on the 8th, and hoping that the teething problems that we had today in terms of interpretation and so forth will be a thing of the past. So I have nothing further to say to you, but to congratulate you for participating in this inaugural training module, and really looking forward to more of us, bring even more friends coming through to join us in the 2nd to the 4th module. Sophia, unless there's anything further, I have nothing further from my end. I would be willing to close the meeting immediately. Sophia? Abiola, did you raise your hand just now? Do you have something to say?
Okay. I'm aware that we don't have time. I had seen, yeah, but it's okay. I have sent a private message to there was a question for me which I had missed, but I will address it.
Okay.
Yeah, thank you.
That's all right. So on that note, I say farewell, goodbye to everybody. I'm closing this meeting now.